I call to order the Special Committee on the Family Division of the Circuit Court of the State of New Hampshire. It is Tuesday, May 16, 2023. Previously, I mentioned previous iterations of looking at the court in recent history. You may recall a task force on family law chaired by the Honorable Henry P. Mock. The task force met between 2002 and 04, issuing a final report on November 1st of that year. The task force had members of the legislature drawn from the House and Senate Judiciary Committees and the House Children and Family Law Committee. Additional members came from various stakeholder groups. Then we were reminded of the 2012 House Committee on Redress of Grievances. Over 24 cases were looked at some length. Recommendations were made both in the area of changes in procedure and towards specific individuals. What I discovered this past weekend in doing some office cleaning was a page describing the Family Court Forum held on May 25th of 2016 at the Upham Walker House. I recall this meeting because I was there. Individuals were allowed to speak for a maximum of 3 minutes, having previously been coached as to their conduct for the speech by then Representative Kimberly Rice. The forum was moderated by then Representative and now Commissioner of Education Frank Edelblu. Among the directions as to content of speeches was this paragraph: "This is not," and it was in boldface italics, "a forum for adjudication. Details of specific cases will not be addressed. Use of specific names of people should not be used. Simply state the judge or the clerk or whatever appropriate title applies." Interestingly, that's kind of the way I got this committee going. Maybe that was in the back of my mind. Additionally, participants were told individuals are encouraged to submit written testimony if they believe 3 minutes is not enough time. In such case, use the 3 minutes to give the highlights of the written testimony. And finally, the document from then reads, individuals speaking are encouraged to share ideas and observations about how the family court system has worked well for them or where there are opportunities for improvement. So I mentioned this at some length because this has not been mentioned as we looked at recent history. Of the previous times when leaders gathered to hear from the public, the way we are functioning here is much more similar to this 2016 iteration than the 2 that came before it, with a couple of exceptions. While we do not have stakeholder groups among the committee members as the first one did, we are affording them times to make presentations. And secondly, we are offering 5 minutes to speak, not 3. Calendar. We will meet once again next week, May 23rd. We will not meet the week after that, which is the day after Memorial Day. We will meet again here on Tuesdays, June 6, 20, and 27 before breaking for the summer. Today, we're going to hear from the New Hampshire Bar Association and then from the New Hampshire Legal Assistants. On June 6, we hope to hear from the Director of Child Support Services. We have others who are finalizing their slots with us for the 20th and 27th of June. June 13th is a court visiting day. It is still being worked out, but we hope to have 3 different family court venues around the state ready to receive us. It is possible that 1 or more of them might choose to give a tour before the actual hearings of the day commence. We hope to know the locations by next week, so members of the committee perhaps could sign up which one they wish to go to, lest we all wind up in one place. Committee researcher Christina Dyer has been working on a few projects for us. One is on the subject of shared parenting. How do various states view this? The other is on RSA 458C, Child Support Guidelines and its legislative history. And yesterday I asked if she could look to see if there was any report from that meeting of 6, 7 years ago at Upper Walker. If there is, we'll find it, we'll make it known. Once again, it has been suggested to me that I read the notice and disclaimer before we begin our work today. The Special Committee on the Family Division of the Circuit Court was formed to investigate allegations of irregularities, including failure to follow or enforce statutes, unwarranted waiver of or failure to follow court rules, delay in rendering decisions, denial of due process, and other procedural issues. The committee will conduct hearings relative to the process of the Family Division of the Circuit Court and may make recommendations for future legislation. The purpose of the committee is to discover areas where changes in procedure or changes in the law regarding the Family Division of the Circuit Court might be made. The purpose of this special committee is not to retry the cases of citizens who disagree with the outcome of litigation. Members of the public will be given the opportunity to testify and present information to the committee. Because of the number of people who may wish to testify, there may be a time limit imposed on each person testifying, which is permissible under House Rule 100. Appropriate subject matter for testifying will be limited to specific instances of where there seem to be irregularities testifying about subject matter related to a court case or who submit documentation related to a court case should know that both will be made part of the public record. Therefore, subject matter that is either confidential or may be under seal should not be discussed or submitted to the committee, as disclosure of such matters would be a violation of statute or of a court order. The committee reserves the right not to accept written or oral testimony or materials which would, in its judgment, violate the foregoing. So, with our little opening boilerplate, we first calling upon, I believe it's the New Hampshire Bar Association. Is that right? And there's one rule that everyone sitting at that table has to observe. Please turn on the microphone. And you know you've done it well because the red light comes on. Thank you.
Thank you. Good morning, Chairman Pearson and distinguished committee members. My name is Catherine Chanelaris. I was contacted by the New Hampshire Bar Association to testify about my experience as a family law practitioner and as a member of the New Hampshire Bar Association's family law section. I appreciate very much the opportunity to talk with you today. I have been a practicing family law attorney for just about 30 years, and I'm here to provide you with my perspective and my understanding as a practitioner working in the court system for a very long time. Just by way of some background about myself, I am one of the founders and partners in my firm, Chanelaris & Shirk, which is located in Nashua. My firm has been operating for 23 years, and we practice exclusively family law, which includes things like divorce, child support matters, guardianship of minors, and parenting cases. Prior to my work at my firm, I was the chief staff attorney at the New Hampshire Department of Health and Human Services for their Division of Child Support Services. I am also a governor at large on the New Hampshire Bar Association's Board of Governors. And lastly, I'm finishing my term as one of the directors on the Board of Directors for 603 Legal Aid, which you know is the legal services organization that provides legal representation and education to qualifying low-income people. And prior to 603 Legal Aid, which was established 2 years ago, One of its predecessor organizations was the Pro Bono Referral System, which I was a board member on that organization for about 20 years. And lastly, I was appointed by the New Hampshire Supreme Court as a commissioner on its Access to Justice Commission, and I've been on that commission since 2007. I have experience both in working in court and working with families, as well as being involved with some of these stakeholder organizations. And I'm hopefully going to provide you with some information and some resources that may be of assistance to the committee. You know, I know, as Representative Pearson mentioned, one of the purposes of the committee is to investigate some irregularities. And it seems like perhaps some of the complaints that have come from the public involve some of the court rules and the rules of evidence. Some of the self-represented litigants, as well as some of us attorneys, sometimes have difficulties with the application of those rules to their particular case type or the particular facts of their case. So I wanted to give the committee some examples today. So for example, the Family Division Circuit Court has a rule, it's Rule 1.28, and it involves what's called an offer of proof. And an offer of proof at court is a statement or a representation made by an attorney or a presentation. Yes, sir.
Are we going to have this in written form?
I can submit it afterwards.
I'd really appreciate if we could get 11 copies of this, because
Sure.
I write pretty fast, but you're really making some good forward motion here.
And let me know if I'm speaking too quickly. I've been accused of that a few times in my life.
I would attest.
So the Family Division Rule 1.28 involves these offers of proof, and it involves presentations, not testimony, but presentations made by an attorney or made by a litigant who is representing himself or herself at court. So, for example, that specific court rule says that the court can exercise its discretion when receiving evidence through an offer of proof. One thing that the rule also says is that if an attorney or a self-represented person is going to make a presentation about something that another witness would testify to, or something that a document they want to present that was drafted by a third person, that third person or witness must be in the courtroom. And the court pretty rigidly adheres to that rule. So for example, lots of times my clients want to give me copies of Facebook page or printed out text messages that somebody else sent them. This court rule would require that whoever's Facebook page that document came from, or whoever's printed out text messages came from, they would need to be sitting in the courtroom. And there's a good reason for that. Prior to this rule being initiated, attorneys and self-represented litigants could submit whatever documents they want. Affidavits signed by family members, affidavits signed by other witnesses. But that person did not need to be in the courtroom. Well, now the court rule says you must be there in order so the other side, the respondent, could cross-examine that witness about that piece of evidence you want to submit. So it is one rule that the court is very stringent about. Sometimes, depending on the record, if it's, for example, a police report or a hospital record, maybe the judge uses his or her discretion to say, I don't need that person in the courtroom. It's an official record by the police department, or it's an official record by, the hospital. Sometimes records are not submitted for the reason they exist. So for example, if I wanted to submit a record, somebody's hospital record, maybe I don't want the judge to use that record in order to show what happened at the hospital. I want that record to show the date that they were in the hospital, because somebody might say, well, you weren't at your work that day. And I would say to the judge, look, here's the record that shows they were at the hospital. But I don't need that record to show what actually happened at the hospital. So this rule says that if you're going to make a representation by a third party or a third party record, they need to be in the courtroom in order to have them cross-examined. The rules of evidence, there's also another.
Yeah, could we stop for a minute
Sure.
here for a question?
Thank you, Chairman Pearson, and thank you for taking my question. I just wanted to clarify. So if it's a text message or a Facebook post, would it just be the person that was screenshotting such evidence that would need to be there? Like, so say somebody had sent me a text message, would it just need to be me that was in the courtroom? Or are you saying that also the person who wrote me the text message would need me in the courtroom? Just wanted to clarify.
No, that's a great question, and it's a good distinction. So if somebody sent it to you, they would not have to be there because you could testify yourself that you received that text message. It's if you want to send someone else's text message or someone else's Facebook page or a document that the school nurse wrote or a teacher wrote, a third person other than yourself having that experience. You're welcome. There also is a court rule, and again, I'm just going to give you the number. It is Rule 2.19, and that particular court rule says that prior to an initial hearing in a family court matter, that evidence, proposed orders, financial affidavits must be submitted 7 days ahead of time. And the judges are very strictly adhering to that rule. So, for example, I can tell you I had my own experience of I submitted documents 6 days before a hearing, and the other attorney was upset that he didn't have them 7 days ahead of time. And the court continued the hearing with good reason so that people can have time to look and vet the information. So oftentimes when people are representing themselves, they're not realizing that they have these rules that they have to comply with. And when they get to court, sometimes the judges are denying them submitting their evidence and documents because they haven't followed the court rule to submit them 7 days ahead of time. The rules of evidence, as this committee may know, do not have technically strict application in family law cases. The rules are applied on a limited basis. Some particular case types, like domestic violence, there is a particular rule that says that the rules of evidence don't apply. I do not do a lot of domestic violence work, but I'm aware of that rule. There are New Hampshire Supreme Court cases going back decades to the 1950s or earlier that talk about holding that the rules of evidence don't have a strict application in these type of family law cases. And despite that rule, that the rules of evidence are not rigidly applied, the court does follow two rules rather strenuously. First is the rule of relevance. Something has to be relevant to the case or relevant to the facts. And the second rule is hearsay. And as I just talked about, that rule 1.28, when you make an offer of proof or you're going to talk about something else somebody said, that person has to be in the courtroom. I have not personally seen the courts avoid following the court rules. It's my experience that the court applies the rules evenly to both attorneys and non-attorney litigants. And the rules obviously are applied very factually to the case, and they're applied depending on the case type. And there's a good reason for that. The reason that, in my opinion, the court rules can't be, the rules of evidence can't be rigidly applied is because the court has to be able to weigh that evidence as the finder of fact. They have to be able to give appropriate weight to a particular piece of evidence. Like I talked about, maybe I don't want the hospital record to be submitted into evidence for the actual, what happened at the hospital. Maybe I want to use the date. And so the judge is permitted under the court rules to give the appropriate weight to certain pieces of evidence, to certain testimony and documents. For example, to make a ruling that's in the best interest of a child or a victim of domestic violence. There are also lots of statutes that sort of give the court this discretion as well. One of them that I can think of in particular is RSA 461-A:6, and it's the best interest standard for a child. And it provides a list of what the court can consider when determining what's in a child's best interest.
So to interrupt you, it's not completely arbitrary. The best interests of the child is not a go for it, judge. There are some parameters set out in 461.
Absolutely.
Thank you.
Absolutely. And as I'm talking about the rules of evidence and the court rules, for example, maybe someone's making an argument in court that a child's home is inappropriate. and someone wants to submit photographs of the home to show that it is appropriate or that it's fine. But that particular statute has a list of things that the court needs to consider.
And this is why, at least I and maybe others in the committee have been told by people high up in the judiciary that we as the legislature not only have the right but may have the specific interest to work on some of those parameters as we perhaps may see as best.
Chairman, I think there, for example, there are a multitude of statutes that pertain to family law cases, too voluminous for me to talk about. And I know you all are aware of them, but to me, there's three main statutes that this committee may want to take a look at, or self-represented people who go to court. The three main statutes, in my mind, are RSA 461-A, which is the parenting statute, RSA 458, which is the divorce law statute, and also applies to unwed parents, and RSA 458-C, which is the child support statute. And in talking about all these rules, the committee may know that there's been a weighted case study by the New Hampshire Supreme Court that showed the need for 32 more clerical staff and 18 more judges in all of the circuit courts, including family division. I did a little bit of research, and it was actually astounding to me that on the court website in 2022, there were over 15,600 new cases filed in just the family division. And when I say new cases, I mean cases that are not reopened, not modification cases, not modifying an existing parenting plan or not modifying child support. Of those cases, over 7,000 cases were divorce and parenting cases, new cases. On average, that's 587 cases, new cases per month. And there were over 3,800 domestic violence cases alone. That's 321 new domestic violence cases, not extension of the domestic violence or anything else that had to do with filing again in a case. Brand new cases.
Which year?
2022.
Thank you.
In my experience, the lack of delay or the lack of consistency relates to there's not enough judges, and equally important, there's not enough clerical staff. Because of my length of time in working in the court system, in the olden days, I'll call it, I remember going to court where court would start at 9 o'clock. And then at 12 o'clock, there would be a break. And then court would start again at 1:30, and everybody knew that. But it's not unusual for court cases now to start at 8 a.m., right when the doors open. It's not unusual, and I have been involved in divorce trials where the judge will say, we're going to work through lunch because I've got 2 other ex parte hearings I need to hear after this. I hear and talk with judges that tell me that they're working on nights and weekends to draft their orders. And I never, 15 years ago, would hear of those kind of things. As important as I mentioned is when the judges make those orders, now there's not enough court staff to process those orders. So the court tries very hard, it's my understanding. And again, I don't intend to be an expert about court process at the clerk's office, but it's my understanding the courts work really hard to get orders out within 30 days. And sometimes it's not possible because there's just a lack of court staff. During COVID, and I don't know if it's still consistent now, at one point the court was down 30% in the clerk's office. That's huge. The judges don't have enough writing time because every second of their day is packed with hearing cases. For example, if I have a divorce trial starting at 9 a.m., oftentimes I'll get there and the bailiff will say, sit outside the courtroom, the judge has to hear an ex parte, an emergency hearing, or there's a domestic violence case that got filed, and now my trial doesn't start till 10 o'clock. And my clients lose that time as well because now we've lost an hour just because there was an emergency that nobody could anticipate or nothing could happen. Again, I don't intend to be an expert on the court process, but for example, every time a domestic violence case is filed, it is filed by the victim, the court has to stop what it's doing to manage that case. So for example, in the already scheduled day of the judge, now they have to read that petition or perhaps talk with the victim before they issue an ex parte order. Once the judge issues that order, the order goes down to the clerk's office, and the clerks have to stop what they're working on in order to process that. And when I say process, they have to enter that domestic violence order into several databases, as I understand it, including the National Crime Information Center and other New Hampshire registries. They have to issue an order to the defendant. They have to contact the sheriff to serve that order. They have to schedule a hearing within 30 days, as the mandates of the domestic violence law state. The defendant can request a hearing in 5 days. So now, if they had a hearing scheduled and the defendant wants to request a sooner hearing, they have to squish that hearing into a 5-day window because of the statute. So you can see that there's an overlay of the court's day is scheduled, and then some emergencies sometimes happen, which cause also further delays. And of course, the divorce and parenting cases and the child support cases and the guardianship cases, they all have the same requirements of scheduling notices and notifying the respondent and scheduling a hearing. I have been in court, for example, recently to schedule final hearings, and the judges are saying we don't have any days at all to schedule until the end of the year or the beginning of next year. So having judges and the court staff, and I know it's an issue of money, but it's important to keep the process going with the correct amount of judges and court staff to deal with that. I want the committee to know there are a number of helpful reports and data, and perhaps you already do know that, on the New Hampshire Judicial Branch website. The reports are broken down by the courts. They're broken down sometimes by the cases and case types, so that's a really helpful resource. And I know, Chairman Pearson, you wanted to keep this committee positive, and there's so many members of the public who need resources, and there's things that they can do to educate themselves and get this information. So I want to talk a little bit about some underutilized resources from my perspective. You know, there's a lot of barriers to the access to justice, but there also are a lot of underutilized resources that I think can help. So again, the court website is terrific. There is a link on the court website that's called self-help. And on that link, members of the public and attorneys, because I use them too, we can find videos about what to expect at court, how to file a domestic violence case, how to file your divorce case, information about first appearance, which is an informational session for parents with children under the age of 18. There are checklists. There are links to the court rules, to the law library, both the state law library and the Franklin Pierce UNH School of Law library, lawyer referral services, legal aid, and most importantly, all the court forms. I printed out just for myself because I wanted to take a look at it. For example, if you wanted to see a checklist about how to file a divorce, it literally starts with some things to consider. There's a section that says, here's all the forms you need, the filing fee, what will happen next, what you need to do at court, and there's multiple checklists, one-page checklists that look like this that can help members of the public figure out how to file their case, and it's super helpful. There's also, you know, the court rules. I know they're long, but they are very easy to understand and very chronological about how a case works. And so I always encourage people to take a look at that. The Bar Association website is also a really great source of information. It also talks about its referral services, has multiple links to the court rules and the laws. There's one service that the New Hampshire Bar Association has worked with the American Bar Association. It's called Free Legal Answers. And it is a really great project with the American Bar Association. And their goal is to have this in all 50 states. And New Hampshire started it a number of years ago, where people who qualify income-wise can ask any legal question they want about process, about their case. They can scan in documents, and New Hampshire attorneys will answer that question for free. I do it myself. It's great because you can log onto that website 24 hours a day and answer anyone's question. There's lots of questions on there, family law questions, landlord-tenant questions, and New Hampshire Bar Association attorneys go on that website and answer those questions for those clients. We provide them with links to forums or websites to take a look at. So that is a really good program. The Bar Association also has a program called Lawline. Lawline is on the second Wednesday of every month from 6 to 8 p.m. and members of the public can call, and New Hampshire attorneys answer the phone and answer their questions for free. Law firms do it as a project. Individual lawyers do it. And so people volunteer to answer these questions. And it's a benefit that the Bar Association provides. The Bar Association also has lots of links on its website for the public related to law-related educational programs and publications that I think can help people. And while I'm not here to speak on behalf of the Access to Justice Commission, I am aware of some of their initiatives, obviously because of my membership on the commission. And I wanted to just talk briefly about some of those initiatives that the Access to Justice Commission is working on. For example, the commission has worked on a pilot project, which has started already, called Court Navigators. There's one navigator in Nashua, in the Circuit Court in Nashua. There's another navigator that floats around to the other circuit courts. And again, it's a pilot project. And those court navigators assist the public in how to file their cases and answering questions about the court system. The Access to Justice Commission has also received the American Rescue Plan Act, or ARPA, funding in 2021, over $1.1 million, to work on various projects to help access to justice, including expanding the Navigator program, as well as educating what we're going to call public navigators, members of the public who might want to volunteer to be a navigator to help people. The other projects that the initiative are working on is simplifying and translating court forms. There are a lot of people who have a barrier to justice because of their language barriers, so we're working on that. We're going to expand the Navigator program. There's some initiatives for alternative dispute resolution. There's going to be a portal for the legal navigators and a virtual court center. And then the commission is also going to collect some data to measure its impacts and success on these projects. The Access to Justice has its own current task force that deal with having the members of the public have attorney access or assisting those with disability. And so the commission also, and I have been personally involved in a pilot program to help work with public libraries. The commission probably knows that a lot of members of the public seek out the libraries for not just their computers and the internet, but actually talk to the librarians and ask them for information about how to deal with their cases. So we're working on a project to educate those librarians and doing public presentations to do things like, how do you draft a will? How do you file your small claims case? Things like that. So there's a lot of great projects that the Access to Justice Commission is working on. You can also, as a committee, go on to the Access to Justice website, which is part of the Judicial Branch website, and see their reports for civil legal needs in New Hampshire. You can also see their annual reports, which are listed there. And there's just so many projects that they're working on, and too voluminous to discuss here, but those reports are really helpful. I'm sure the committee has heard previous testimony that 80% of every family law case in the circuit court has at least one self-represented individual, if not two self-represented individuals on a case. And the law in the domestic relations area is complex. For example, self-represented litigants are expected to draft their decree of divorce about how to divide their retirement accounts. And I work as a consultant for some other attorneys to draft those special documents to divide retirement accounts, and they're complex. But there are a lot of stakeholders in New Hampshire working really hard to help those people who want to represent themselves or who need to represent themselves. And I know I've only skimmed the tip of the iceberg this morning, so I'm happy to answer any questions that anyone has.
We're going to take a breath first. This was incredible. Thank you. Representative Gregg, you go first because
Thank
of your
you, Mr.
dad.
Chairman.
Okay.
Oh, thanks.
Yeah. Father.
Get a pass. Thank you so much. This has been super informative. I really appreciate it. So in the area of domestic violence, which has got more complications than I think we have people in the state, is there a particular resource that's available for pro se litigants in that? I know that's even more complicated when it's pro se given the dynamics of that, but for both sides, like where, what are the resources really for them? Is it the Bar Association or?
It's a really good question. Thank you for that question, Representative. To me, the number one resource is a project called the DOVE Project, D-O-V-E, from the New Hampshire Bar Association. And they help victims of domestic violence connect up with an attorney, and they do that quickly. And I'm really happy to say that there are a lot of New Hampshire attorneys that take those cases. If a case is scheduled within 5 days, I mean, sometimes you have very little time to prepare as an attorney or as a litigant to go to that case. So that's number one. People can also go to places like the YWCA. There's places like in Nashua, for example, Bridges, which is a place that helps domestic violence victims. But I would always recommend that they call the New Hampshire Bar Association. That DOVE project, they work very quickly and try to find people an attorney very fast. It's difficult in domestic violence cases because, again, I don't practice them very often at all. But victims are limited to what they say in their petition. So it's really important when they draft that petition to make sure that they have all the facts that they want to say in there. Otherwise, they're precluded by the court rules and the domestic violence protocols from talking about things outside the scope of their petition. So it's helpful even if they could just meet with an attorney to help them craft their petition. It would help them a lot.
Fantastic. Thank you so much.
You're welcome.
Representative Long.
Thank you, Mr. Chairman. Thank you. This is very helpful. With respect to the submission of evidence, 7 days, is that calendar days? Or
Calendar days.
it is calendar days?
Yes,
so
obviously if it falls on a weekend, then it goes to that Monday. Yes.
Okay, so if, follow up if I may. If
Follow
there's so if it's Friday, Saturday and Sunday is 2 days?
If it's a Friday, if it's the seventh day is on a Friday, it would be due on a Friday. But let's say that day 7 was on Saturday,
Okay,
then
be
it
the
would go to the
following
Monday. Yes.
Very good. Thank you.
Representative Smith.
Thank you very much. We're all exhausted. I assume you are also, because it was an incredible presentation. In New Hampshire, in order to practice law, you must be a member of the Bar Association.
Yes.
And that differs in other states. Is that not true?
It does differ, and I wish I could answer your question about how many states require bar association, that people join their bar association, the number of states where it is mandatory, not just New Hampshire.
If I could just follow up. In that case, if I wanted to be casual about it, I would say that the Bar Association, in effect, becomes a wholly owned subsidiary of the court system. Does that relationship potentially interfere in any way with not individual attorneys, but the association being able to challenge or question court procedures?
So the Bar Association was created by the New Hampshire Supreme Court. And I can't remember the year. I should know that year, but I believe it was in the 1970s. So we are a creation of the New Hampshire Supreme Court. The Bar Association has its own bylaws, it has its own rules, and it has its own way to function, even though we were created by the New Hampshire Supreme Court. So I believe that the Bar Association has a good relationship with the court system. But to answer your question, can the Bar Association challenge or request changes to the court rules? The answer is yes.
Representative Macbeth.
Thank you. And I've got a horse.
Welcome
Thank
to
you.
allergy season.
Thank you for taking my question. I'm wondering if you'd care to comment on, we've had testimony from pro se litigants concerned about their orders being fair, and a lot of ways that maybe arguments that could have been presented to make those orders more fair. I'm wondering, is it the judge's responsibility to come up with arguments for pro se litigants, or is that something that a pro se litigant is just accepting that they may not have the full opportunity for all the laws to be applied to their case if they don't bring it forward?
I appreciate your question. Thank you. One thing that I do as an attorney, and I think I have a lot of clients that will come to see me and they want to represent themselves in court, but they come to me just looking for some advice. The one thing that I think is very, very important is having your proposed orders ready 7 days before a hearing. And when I prepare myself, I go through those forms and say, okay, I need to talk about parenting or the parenting schedule, or I need to talk about health insurance and a divorce. So if a self-represented person would go through those proposed orders and just make a list of everything they actually wanted to talk about, because I know it's daunting, it's nerve-wracking when you're in court and representing yourself and trying to remember everything. But just being able to go over what proposals you might be requesting of the judge will help bring those to the judge's attention. I would also say that when people are self-represented, I have seen the judges often ask them some questions to bring out the information. It's not the judge's place, in my opinion, to make the arguments for the person, but they will ask the questions that the court needs to hear the answers to in order to make those orders. And so that's sort of my two-place answer to basically say having your proposals ready for court is really helpful because it gets your mind in a place of what you need to discuss, and then the judge will sometimes ask those questions to bring out the answers.
When I thought it would be a good idea to print out the New Hampshire Rules of Evidence, little did I realize. But there's I don't know if it's Cliff Notes, but it is New Hampshire Rules of Evidence. They're listing Rule 100, 103, 1.2, 1.28, which you spoke to, and 2.2. Which I believe the person who prepared this for me thinks, perhaps correctly, this is specifically to family courts. Is there a longer document than this that is specifically to family court?
It's an excellent question, Chairman. So on the court website, the court rules are there with, which is really great, with a searchable index. And so there are general rules of the circuit court that apply to all the circuit court cases. And then you can go down into the section that just deals with the domestic relation rules. And they break them down, juvenile cases, guardianship cases. But yes, you can see just the rules specific to the family court.
Thank you. I'm reading here Rule 2.2, Application of New Hampshire Rules of Evidence. The New Hampshire Rules of Evidence do not apply to the actions listed above. However, the court, in its discretion, may utilize the New Hampshire Rules of Evidence. So far, this seems to track with what a lot of people are objecting to. They don't follow the rules of evidence. No, they don't have to. But it continues. The discretion may utilize the New Hampshire rules of evidence to enhance predictability, orderly, fair, and reliable presentation of evidence. So there does seem to be some narrowing. So those who would think family court has to follow all of this are missing the point. But if, in their opinion, the judge did not follow the rules of evidence, even though, in the objector's opinion, it would have enhanced the predictable, orderly, fair, and reliable presentation. Maybe they have a beef. Maybe they have a valid objection. Would that be a fair narrowing of the objections that are sometimes made that a judge does not follow rules of evidence?
In my testimony, I do feel that the court pretty much always follows the rules of relevance and hearsay. And I talked about that. I think it would be difficult for the legislature to make a rule that says that the rules of evidence in family law cases must apply, because I think that takes away some of the discretion of the judges to get to what might be in the best interest of a child, or get what might be in the best interest of a family. Sometimes the judge may have to look at a piece of evidence that doesn't strictly adhere to the rules of evidence in order to get to a decision, including in domestic violence cases where those hearings happen so quickly. And if we're going to have every witness there, or we're going to comply with the rules, that 5-day rule, in order to have that domestic violence victim be able to be entitled to a hearing, might not be able to be adhered to. So I appreciate that, and I understand that. But in my experience, I don't think the judges just take every piece of evidence. It has to be relevant. It has to follow that rule of hearsay, and it has to be related to either the facts or the case at hand, not just something unrelated.
See, this is where I'm trying to help those who bring testimony to narrow it. Because if it's just some broad assertion, they don't follow the rules, that is not helpful to us. It's not helpful to their cause. So if we can narrow to those parameters you have spoken of, and then we are presented with documentation that perhaps within those rules, that parameter you gave, it wasn't followed, then I want to see how frequently is that? Is that somebody having a bad day? Did somebody make a mistake, which we all do? Or is this more widespread? And if it is, then what do we do? Because I think I agree with you, passing a law on this wouldn't be the right way to fix the problem, but I don't know what the right way is.
And you know, Chairman, I would also take a look at some of the New Hampshire Supreme Court cases. There are multiple cases that talk about why the rules of evidence don't rigidly apply in family law cases. And as I mentioned before, some of them going back to the 1950s. And those cases have been followed over and over again by the New Hampshire Supreme Court. But some of the dicta and some of the reasonings in those cases, I think, would be helpful for the committee to take a look at.
Gosh. I wonder if we could have some of those found. That was a yes. Thank you. After the 52 other projects I've dumped on you. Thank you. Representative Smith.
Thank you. This is, again, a slightly different question. For very understandable reasons, when our sessions move to the last part of the morning and we hear from individuals, not people here representing agencies or institutions, no one has come to say, we think the family court is absolutely fabulous. Everyone who has come is someone who feels that they were not treated justly. And of course, the individual on the other side in their case is not here. So we are not an appellate court, and we have no intention of being an appellate court. But it means that we might lose our ability to discern what really is happening in family court. Are we hearing from 50% of the cases? Are we here, or is what we're hearing representing 50% of the cases, or 25, or 10, or 5? We have no way of knowing that. In your experience in the court, can you help give us some perception of what actually is happening overwhelmingly in the court, in no way minimizing the pain and anguish that individuals feel?
Thank you for your question. Family court cases are, of course, some of the most difficult, and I have been involved in a lot of difficult cases. Parents that are doing the best for their kids, parents that are, struggling with alcohol abuse or drug abuse. One thing that I think the court has done, which has been really helpful over the last, I don't know, it's changed a lot. Early on in my career, the court might make an order where somebody files a motion. And that motion, the court order might just come back with the word denied. No explanation, no discussion about what happened. The courts try really hard now to make very detailed orders. They refer to the statute that they looked at. Sometimes they include the statute in the court order. They'll talk a lot about the facts. I can think of a lot of cases where I'm involved in where the judge has said that this person testified to this, or this attorney said this, and put those facts in the court order. So over time, I feel that the courts have worked really hard to make more detailed court orders with more detailed reasons and rationales for why they're making an order. So those final orders or those orders on motions have been a lot more detailed. And so I think that perhaps the committee may want to take a look at some of those court orders where they can see what the judge has done and given the rationale for why they've made that decision. And sometimes, as I've said this morning, it's a matter of somebody not reading the rule or not knowing how a rule applies to their case, or not understanding that, where maybe they've lost something because the rule wasn't followed, or the statute, the burden under a statute wasn't met. But I think the courts work very hard to make very detailed orders to explain their rationale when they're making a decision. And that is something that has changed over time.
Thank you. If I could just follow up, do you have any, from your perspective, can you generally suggest that most people who go through the family court system feel that they have not been treated well, or half of the people, or 25%, or is there any, obviously I don't mean a specific number, but what we hear is all focused in one way, and we need to have some sense of perspective.
And I appreciate that. I can honestly say from my own perspective, I have never seen a judge be disrespectful to a self-represented litigant. Matter of fact, some of us attorneys sometimes complain that,
Excuse me.
some attorneys complain that sometimes the self-represented litigant is given more time to talk or more time to testify in order to get that in there. I'm sure, I can tell that there are people that feel differently, but I have not seen it. I had a 2-day trial last fall with a gentleman who represented himself for 2 days in court. And the court he did a great job, and the court gave him all the time he needed to be able to have his witnesses and his testimony. And I didn't see any disrespect from the judge in that case. And I have not seen the judges yell at self-represented litigants or treat them disrespectfully. They may They may try to shorten what they say sometimes because they're either getting to a place where something's irrelevant or something's not applicable. But I have not personally seen that myself.
Representative Katab.
Thank you, Chairman Pearson. I just wanted to kind of follow up on what you just said, just to ask a further question. Do you practice specifically in certain courts, or do you typically go to all of the courts? Because perhaps some of the issues that people are experiencing may just have been at a court that you don't typically practice at. So I was just trying to, ascertain where you typically practice, or if you go to all the courts.
Thank you. So mostly, because I'm in Nashua, I mostly practice in the Nashua and Merrimack family divisions, but I'm also in Derry family division, Salem, Concord. I don't tend to go too far north because it's not sustainable for clients to hire me that far away, but I have cases in Keene. So I do practice in a number of the family division courts. Thank you.
Representative McMahon.
Thank you, Mr. Chairman. Attorney Chandelaris, you made a comment earlier. I want to ask your guidance on this, where relative to the rules of evidence, rules of relevance, whereas the judges are so-called the finder of fact, and I say so-called, depends on what facts are being presented. Your statement that stood out to me was you stated they do not have consistent application. However, your opinion is they're fairly applied. So isn't that an inherent contradiction? And because of that, do we need to consider additional rules of how evidence and relevance of said evidence are provided so each entity, the defendant and plaintiff, are fairly accessible to the court's power?
Thank you for your question, Representative. In my opinion, it would be difficult because of the factual nature of family law cases. So when I say that the judges are the trier of the facts, so in jury cases the juries determine the facts, but in family law cases the judges are the judges and they are the determiner of the facts. And because the cases are so factual, it would be hard, in my opinion, to make a hard and fast rule to say that certain pieces of evidence need to travel a certain path before they're admitted into evidence. I think it depends on the testimony and it depends on the facts of the case. So it's not that the courts don't contemplate how to receive evidence, because evidence has to be authenticated. Evidence has to be, where did this come from? I just can't submit a piece of evidence and say, oh, I want you to look at this, judge. Well, the judge will want to know what it is. Where did it come from? Who generated it? There's lots of questions that get asked by the judge that are consistent. But whether the judge accepts a piece of evidence or not, again, in my opinion, I think it's very relevant to what the facts are of the case and what the court needs to consider. It's difficult.
A follow-up, Mr.
Follow-up.
Chairman? Very briefly. One question, then one to follow real quick after that. Would you recommend black letter law rules to be added to ensure what you just stated takes place?
It's hard for me to make a recommendation on behalf of the courts, and I don't want to try to do that. But I guess what I'm trying to say, hopefully not too inarticulately, is that I think it's difficult to make very definitive rules for admitting evidence because of how the facts that the judge has to hear and what the judge needs to be able to meet the burden under a certain law, and what might need to happen. Whether the judge looks at a video or whether the judge looks at a photograph, it's just so factually related to what might be in that video or on that photograph. And I think the judge needs to consider that depending on what testimony or presentation was made by the litigants. So it's very difficult, in my opinion, to make something very rigid to say this is what someone absolutely needs to do to submit a piece of evidence.
Stipulate to that. Okay, last question. I'll ask your guidance on this. You referred to the commission, your commissioner on the Access to Justice Commission.
Yes.
And what I've heard from previous testimony, there's also a New Hampshire Court Improvement Project. Are you aware of that? And is there a consensus that could come to help in these type of questions that we're dealing with from those organizations?
I'm not really familiar with that project, Representative. I do know there are lots of other entities. The Bar Association has a committee on the cooperation with the courts that has judges and lawyers that are also on that committee. There's lots of entities that I think help the court communicate with the public and with lawyers. So I'm not aware of the work of that particular group.
Okay, thank you very much, Attorney. Thank you,
Thank
Mr.
you.
Chairman.
In listening to what numbers of people have brought forward, they focus on, but this is facts. And I'm looking at Rule 401, the test for relevant evidence. Granted, this is, but still, evidence is relevant if it has any tendency to make a fact more or less probable than it would be without the evidence. The fact is of consequence in determining actions. I can see all kinds of facts that might want to be brought up, but don't help the case, so the judge may not accept it because it doesn't serve the purpose of the trial. Would I be roughly on track here?
I think you are, Chairman, and I also think that what happens is those facts, there's a burden under the statutes, whatever statute you're trying to prove. So for example, if you're trying to relocate with your child to another state, there, RSA 461-A, colon 11 and 12 deal with those kind of relocations. And so some facts help you meet the burden under the law and some facts don't. So I would agree with your statement.
I do have one, it looks like final question for you, and that is, would you review how disciplinary cases of attorneys are done? Certainly, I do not mean specific names or specific instances, but should a hypothetical come your way, what is the process?
Thank you for that question. I will admit that I'm going to knock on some wood that I've not had to experience that process myself. But New Hampshire has an attorney discipline office and a website. And I know that you can get the process, or you can go through the process if you go to that website, Chairman, and be able to see exactly what needs to be done. And I'm not, without referencing materials on that website, I'm not totally familiar of the deadlines that need to happen, but I know that members of the public can file, or attorneys or judges can file a complaint when an attorney has violated a rule, and then that process starts. But that website would be very helpful.
And that website would tell us what percentage of those who would eventually pass judgment are themselves fellow members of the Bar Association, as opposed to people who are independent of that?
I'm not sure if you can see the percentages, but you can see all the disciplinary decisions made on that website.
What I'm striving for is not specifically a decision against attorney so-and-so, but if there were 10 members of the group that makes the determination and metes out a punishment of some degree, 2 lawyers and 8 members of the public versus 8 lawyers and 2 members of the public begs questions. And would that website tell us?
I'm not sure, Chairman, but you could call the Attorney Discipline Office, and I know they're very helpful and be able to point you in the right direction or answer your questions about that.
Thank you. Representative Macbeth.
Thank you for taking my question. I just wanted to follow up. Are you aware, in malpractice, are family law attorneys, are they likely to have increased malpractice rates? Are they, do they practice in an area that frequently litigants are unhappy?
Thank you for that question. So I only know from my own malpractice carrier and the legal education classes I take from them that it seems like family law is one of the top, if not the top, areas of malpractice. Along with real estate, I believe those are the top 2 areas, but I'm not positive that. I only know that from my own malpractice carrier.
Representative Ball.
Thank you, Chairman Pearson. In your opinion or in your experience, just wondering, have you witnessed or do you believe it's possible that there could be a bias just when the parents walk into the courtroom? Is there already a bias?
I think that there are lots of studies about inherent bias for judges, litigants, attorneys. I don't know if the courts or the legal system has done any work about those kind of inherent biases, but I don't outwardly see a bias on just how people walking into the courtroom are walking into the courtroom. But I know those certain biases do exist.
Follow up, please.
Follow up.
In going with that, I'm just going to ask this question, and I do not want to diminish domestic violence or anything, but just because of people who have come to testify and because of constituents who have reached out to me. In your opinion, do you see a way where the family court can actually be weaponized against one parent?
You know, it's a tough question because I think sometimes people file cases, they file motions, they file things because sometimes people believe that's what they need to do. I've seen it work the other way. I've been involved in a case where a self-represented parent has filed over, 200 motions and, requests and things like that. So I think it works both ways, but I think, perhaps that's how somebody might feel. But I think it's up to the court to try to deal with, people filing, duplicative pleadings or multiple pleadings. But sure, I think that sometimes the court has to receive in motions from attorneys and litigants that they need to deal with. And there are lots of cases where there are multiple things filed and cases go on for a very long time. Yes.
One last follow-up.
Follow up.
please. And do you feel that or in your professional opinion, if there was a presumption going into court of 50-50 parenting, do you feel that that might lessen the animosity of one parent against another to try and get full custody, or just to use, as I said, to weaponize the court to hurt the other?
One form that I think that the committee might want to take a look at is the parenting plan from the family division. The very first page of the parenting plan outlines what the understanding from the legislature and the courts about parenting. And there's I won't call it a presumption. There's not a presumption in the law, in my opinion, but there is sort of a presumption that children do best when they have frequent and continuing contact with both parents. And I do believe the court tries to start with that premise. And then the facts come out about why a parent might not be able to have 50% parenting time based on what's in the best interest of a child. That's the perspective the court always comes from. Again, in my opinion, they look at, I tell my own clients, sometimes it's not that the court doesn't care about them, but they really care about kids and they want to make sure that kids are safe. And so when you look at that parenting plan, you can see those, the things that the court considers when they're making a parenting. And I think they do start from a place where both parents should have parenting time with the kids. What that parenting time should be really starts to depend on the facts and then how somebody meets their burden under the law.
Thank you very much. I appreciate you taking my questions, and I appreciate your honesty. Thank you.
And thank you, Attorney Chanelaris, for coming, and we'll look forward to having photocopies of your presentation.
We'll do that. Thank you all so much for
Thank you.
taking the time to hear my testimony today.
And next, we recognize the New Hampshire Legal Assistance folks, or folk, or person. Not just. We hope you are just, but you're not just.
I do my best.
Okay.
Just give it to an end person and they'll share it. Thank you.
Good morning, Mr. Chairman and members of the committee. Thank you so much for inviting me to speak with you all today. My name is Erin Jacina, and I direct the Domestic Violence Advocacy Project at New Hampshire Legal Assistance.
Are you a lawyer?
I am not a lawyer. I am a paralegal, and I'm happy to say that under Rule 35, which is a new Supreme Court rule, I am now able to practice under a pilot project in Manchester, Berlin, and Franklin in domestic violence and family law cases. And I have participated and conducted 4 hearings myself so far since January 1.
Do you practice solely, or
I, under the Rule 35, I am required to be supervised by attorneys, and I am supervised by attorneys in my law firm. There are a number of requirements that go along with this new rule and the law that was passed by the legislature. So I want to first thank all of you. It has increased access for our clients and New Hampshire residents to access justice. So thank you for that. And happy to answer any questions about the paraprofessional pilot project at any point if anyone has any questions.
my aunt was a pilot project nurse practitioner 50 years ago, so I understand the concept. Yeah, thank you.
Great, thank you. So New Hampshire Legal Assistance is a statewide nonprofit law firm. Our attorneys and paralegals represent low-income and aging clients in civil cases involving urgent and basic needs, including safety from domestic violence and stalking. Our Domestic Violence Advocacy Project, or DVAP, represents low-income victims and survivors of domestic violence, sexual assault, and stalking in their high lethality protective order cases and in their family court cases. So that's the divorce, parenting. And when I refer to high lethality cases, that means there's a high likelihood that the victim will be killed or seriously injured by their intimate partner. And just for some context, in 2022, NHLA represented nearly 200 clients in family division cases statewide. So again, we are a statewide nonprofit law firm, so that gives us a unique perspective. So I thought it would be a good idea to, and hopefully I didn't miss the mark here, to go through the start of the inception of the family division. And then to talk a little bit about the goals of the family division when it was first created back in 2004. Really, are those goals being met in today's world, in today's family division world? And then what might we do going forward? How can we make things better? I think that's what the goal of this committee is. It's the goal of stakeholders. I know the public is invested. So what can we do to improve the services that are being provided to litigants and those accessing the family division through the circuit court? So as you can see, I put the statute in from 2004 that created the family division within the judicial branch. And then I broke it down really into 4 different goals. And I'll start with goal 1. The first goal of the family division was really to create the respectful treatment of all citizens by justices, marital masters, and other family division staff. And I know you have all heard in this committee and also in the Children and Family Law Committee from many public coming forward where they are saying that's simply not the case. And I do want to respect and honor their experiences. And those are individual experiences. And I definitely hear what litigants are saying, that they may not have received the respectful treatment that they should be receiving under the statute. So what are the remedies to that? So if somebody is not getting this respectful treatment by the justices, what can that person do? They can make a complaint to the Judicial Conduct Committee. They can complete a circuit court judicial evaluation on the court's website. If you go to the judicial court website, it's not all of the justices. You can go to the particular division and it will list, I don't know, maybe 4 or 5 judges that are up for evaluation. I think they're on a rotating schedule, and anyone can go and complete an evaluation. So that is certainly an option for people.
Complete an evaluation if that judge is listed. What if that judge was evaluated last year and you're now having a bad experience? How long do you have to wait before that person's going to rotate up again?
I don't know exactly what the rotation is, Mr. Chairman, but in that case, I would certainly reach out to the Judicial Conduct Committee. So there are multiple options. So not only evaluation, but the Judicial Conduct Committee course, there's the appellate process if you're having a specific issue with your case. Goal number 2 is the prompt and fair resolution of family issues. And the second part of that goal is that there are specially selected and trained justices and marital masters. So is this happening? And if not, why not? So you heard Attorney Chanelaris talk about the judge shortage. That is certainly true. We've talked about the backed up dockets. And I wanted to give some context about the backed up dockets. There are cases that require certain statutory guidelines where cases have to be heard within a period of time. So domestic violence cases, stalking cases have to be heard within 30 days. The defendant is able to expedite those cases. So the case has to be heard within 5 days. If somebody files an ex parte motion within their parenting or divorce case, those cases have to be heard within 30 days. So there are emergency type cases that are happening that need to be heard within that time frame. So it bumps the regularly scheduled cases, let's say. So in addition to that issue, COVID was a huge issue. The courts essentially, with the exception of with the exception of emergency type cases, the courts essentially had to shut down when COVID happened, much like the rest of the state. So you had all of those cases that were pending pre-COVID, all those cases that had hearings scheduled, trials scheduled, and those had to be put on hold unless it was an emergency. So then but life doesn't stop. Life didn't stop with COVID. And people were still having issues. People still wanted to get divorced. People still wanted to be separated from their partner and needed parenting plans. So filings were still happening. They just weren't necessarily getting scheduled for hearings. So you had all of the cases pre-COVID that needed to be rescheduled. And then you had all of the cases that were being filed or people wanted to file during COVID. So it just really overloaded the docket. And they're working really hard to try to figure that out and prioritize. But yes, it's not always leading to the prompt resolution of these matters. We've talked about there not being enough judges. And then in terms of the training, the judges need training. Absolutely. Training is important. In all professions, training is important. And it's important to be updated on, what are the current best policies and practices. But the problem when you take the judges off the bench to do the training, it creates more delays because they're not hearing cases. So that's certainly something to consider.
That's what the Chief Justice told me when I gave him several things that continuing education could be added to all the justices in the state.
Absolutely.
And he said, thank you for the 7 judges you're getting us in the budget. I said, we'll see, but we'll probably need even more if we have more continuing ed.
Yes.
Yeah.
Yes. So then, the statute talks about specially selected and trained. So what does that mean? So the circuit court is made up of 3 divisions. It's made up of the family division, it's made up of the probate division, and it's made up of the district division. And this was really, it was created with thought, and it was meant to create an ease within the circuit court so that a judge in district court could hear a family division case, or a probate judge could hear a district court case. So that they could seamlessly move between these different case types. But then you have to think, does that make sense? Does it make sense for a judge who, primarily listens to misdemeanor drug charge cases on a daily basis to then try to figure out the complex nature of the best interest standard in a family court case? Does that make sense? It may have made sense back in 2004, but does it make sense today? Or does it make more sense, to continue this circuit court, but have specialties within the circuit court, like what it was intended to be probably, which is a judge would hear a specific case type and would be very knowledgeable and have expertise in that particular area. So then goal number 3 was the use of alternative dispute resolution to reduce the adversarial nature of proceedings involving families. So I broke this down into the pros and cons. And is this happening? I would say alternative dispute resolution is happening. And when I say alternative dispute resolution, I'm referring to what we commonly talk about as mediation. Is mediation happening? Yes. In my opinion, is it heavy-handed? Yes. Why is it heavy-handed? Because it's an easy way for the docket to be cleared up. It's if cases can be resolved through mediation, that's great. You have a certified family mediator, or maybe you're using a private mediator, and you can meet and amicably and safely meet both parties to come together and come to a good resolution of the case. And what does that mean? That means that that's one less case on the court's docket, one less case taking up time. So yes, there is, in my opinion, a real push for cases to go through mediation. I'm coming at it from a domestic violence perspective, and mediation in domestic violence cases is not generally safe. There's the actual physical safety involved with mediating cases, but then there's that underlying coercive control. If you have one party who is an abuser, are they really meeting in good faith to resolve the case, or are they really meeting because it's a further way to abuse their partner through the court system? So that's a consideration. Are cases inappropriately going to mediation? Should cases be going to mediation? And if so, which ones? Because mediation has a lot of benefits in addition to, freeing up the docket a little bit. But it really also embodies the mission of the family court system, which is to reduce conflict between the parties. And reduce the tension, and to honor and acknowledge that this is a difficult time for parties going through this. I'm sure when parties got together, they weren't initially thinking, I'm going to get divorced, or we're going to have kids together, and then we're going to have to figure out who has parenting time and when, and how our exchange is going to happen. So just honoring the experience that litigants are going through. So if parties are able to safely and amicably reach a resolution through mediation, that's great. But that's not all cases, and that's certainly not most domestic violence cases. And then particularly in domestic violence cases, if you have cases that are resolved through mediation, but there was that coercive control component involved, then that agreement, that final agreement, isn't going to hold up. It might hold up for 30 days, it might hold up for 6 months, but inevitably, if the parent who was abused, made that agreement because they felt that they didn't have another option, then down the line, it's going to fall apart. It's not going to work. It's going to be the holidays. It's going to be what was agreed to in terms of the parenting schedule. So what does that mean? That means then the case is going to be litigated, but it's going to go back as a modification case. And that will, that increases the court's docket. And then goal number 4, the assignment of all family matters of a single family to one family division justice or marital master. So I already spoke to this a little bit, but is this happening? No, it's not really happening. And this isn't me faulting the court in any way. This is recognizing that there are issues that don't allow for this to happen. One is that contested cases go on for years at times. We used to, in our experience, contested divorce parenting cases could take 1 or 2 years to resolve. That's what we would tell our clients. But since COVID, we're looking at potentially 3-4 years to resolve. And in that 3 to 4 years, are you going to have the same judge hearing the case? Probably not. You might for a little while, but then judges are frequently rotated among the family courts, among the family divisions. So you might have a different judge in year 2, and then you're finding yourselves retelling the facts of the case. The judge has the file and will read the file, but they haven't been invested in the case for the last year. So now you have to take the time to really relitigate what you've gone through for the past year, because you really want the judge to understand what's been happening. So this is hard. It was in the statute. It's not happening, and there are a lot of reasons why it's not happening. But I think as you consider what recommendations you might make, I think consistency is key. And I have spoken about consistency in the family court system in different forums, but consistency is key across the state. It helps litigants understand and have an idea of what to expect. If you have the same judge hearing your case, if you have the same judge that's hearing the domestic violence case, but then also here's the parenting case, they already know the parties. They know what's happening. They know the kiddos. They understand the dynamics of this particular case. But let's say that judge gets moved. They were in Manchester and then they get moved to Claremont. And then you have a judge that's coming from Portsmouth. It sets up a whole different dynamic. And what if that judge doesn't, uses a different process in terms of how they want evidence submitted or how they want the form submitted. So consistency is key. It helps practitioners, it helps lawyers figure out what is wanted when they're trying a case, but it also helps litigants to understand what's expected of me. So I would really urge you to look at this goal and say, is that something that's feasible? Is it possible to have, more consistency in judges sitting on particular cases? So then I want to talk a little bit about the barriers reaching some of these goals, and I know I've touched on some of them already. But I think generally there's a lack of understanding of the family court system. It's not anyone's fault. A lot of times people don't have, they don't know what to expect because they've never gone through the process. If you haven't filed for divorce or you haven't filed a domestic violence petition, you don't know what you're going to get when you walk through the door, particularly if you're self-represented. And I think a lot of people, their experience is based on what they see on TV, and it's not that experience.
Would you say that the TV show Night Court is not representative of Night Court in this state?
Great show. But yes, I would
You
say that
admitted
is-
to watching. Thank you. Gotcha.
Are we talking the spin-off or are we talking the original?
Yes, we are.
The original. Okay, yes, excellent show, but not the same, not at all. There's no jury. It's just a very different process. So I think lack of understanding of the family court system is one barrier. Disparity in income and resources between the parties. One party might have the resources to hire an attorney, the other party may not. And we represent clients free of charge, but we don't have the resources to serve everyone that comes through our door. I wish that we did, but we are turning many, many people away. And oftentimes the cases that we are getting are either so complex that they're not appropriate maybe for a volunteer attorney. So if we're not taking the case, then no one is taking the case and the person is going to court unrepresented and self-represented. The party's ability to hire a GAL, there's no longer a court fund that pays for guardians ad litem. So what does that mean? GALs still participate in cases. They're still ordered for a GAL to be appointed in a case, but those are only cases where one of the parties or both of the parties have the resources to pay for a GAL. So what does that set up in terms of a system? Particularly in domestic violence case, again, you've got the power and control dynamic. What happens if dad has all of the money and mom has stayed home and dad has been abusive? Dad can hire the GAL and dad recommends the GAL, and that's the GAL that gets appointed to the case. Well, how does that, from the perspective of mom, and the vulnerable parent, is mom going to feel comfortable in that case talking to the GAL, knowing that her abusive spouse is paying for the GAL? It just sets up a bad system or lack of a fair system. Then there is an intersect between DCYF and the court system. Let's say there's a report made to DCYF that abuse is occurring in the home, either to one of the parents or to the kiddos or to both. A report is made and DCYF advises the parent, the vulnerable parent, to go file a parenting petition or go get a domestic violence order. That may be at some point the right answer, but in that moment, it may not be the safest answer for that person. So let's say the parent does that, follows the advice of DCYF, and they do that. But then the court says, well, what's DCYF doing? Is DCYF involved? Well, no, DCYF has closed the case because mom is, or the vulnerable parent is going to take steps to protect the child. So DCYF says, okay, closing the case, mom has made an effort to protect the child. Family court will take it from here. Well, family court looks at it and says DCYF isn't involved. So DCYF isn't involved. So is there an issue here? DCYF closed the case saying it's unfounded. So it's this cycle of, you know, there is a concern, but both sides are really, they're hoping for input from the other side, and it's just not happening. Yes.
Yes, Chair recognizes the Vice Chair with a question.
I don't want to break your train of thought.
No, it's okay.
But what you laid out did not seem to me to end up with DCYF having justification to say unfounded. What DCYF could say is founded with one of the principals taking action. How can they justify saying unfounded?
And I don't work for DCYF, and I'm only speaking on what I have seen in the cases that we have handled and what people have reported to me. And I know a lot goes into what rises to the level of a finding. But it has seemed that what does happen is that perhaps it could rise to a level of a finding, but what they have seen is that mom or the victim parent, vulnerable parent, is taking steps to protect the child, and that satisfies some of the requirements. And so they, in some cases, I'm sure they do make a finding, but oftentimes it's unfounded. And then they're left to go to the family court without a finding from DCYF based on the abuse that they've alleged.
Mr. Chair, I wonder if I could ask you to consider raising this question with the appropriate representative from DCYF about exactly how they handle a situation when they see that there is a problem, and also see that steps are being taken by one of the principals. Because on the trust but verify approach that many of us feel comfortable with, I completely accept everything you say, and yet I cannot imagine, I cannot be comfortable with that, in fact, representing the ease with which DCIF could pass off the case.
Again, I'm not suggesting that there is necessarily an ease, and there is a thought process, but a lot of it is on the onus of the parent to protect the child and
Thank
to
you.
take the steps.
Maybe I can suggest that all my friends from your group and DCYF and the courts have a wonderful time in mediation, finding this beautiful, wonderful protocol that works so wonderfully for the children and everybody else involved, because you're, I think, pretty much good people trying to do good things. And sometimes the system needs to be looked at and said, how come good people trying to do good things isn't always working? And I'm wondering if that conversation could be had.
Yes, and I also want to assure everyone that, you know, I want you all to have a clear picture from our perspective of what our experience has been. I don't think you're able to make the recommendations that you need to make if we're not all very upfront with what is happening within the system, and how we can fix it. And
Hey, hey, quiet. Audience will be quiet or we'll leave.
And we are 100% having these conversations, and our goal is to make things better, and we make things better by having those difficult conversations.
So this working together is an ongoing process. So we're going to hear very, very few cases going forward because of, whoops, how did we come up with something that just isn't working
It's
here?
not a perfect system.
No, it's
and
not, but it can be better.
It 100% could be better on all forums.
Okay.
This isn't just the court or DCYF or, one particular agency or group. We all need to work collectively. And if I'm able to get through the rest of my presentation, I will absolutely let you know the good work that all of these groups are doing.
You will. And could we have a report back in September as to how you don't have to go into details unless we have to make some recommendations or legislation out of it, but just a little note signed by everybody that, hey, we met over hot dogs over the summer and we had a wonderful time and tossed the Frisbee and ate corn on the cob and worked out some of these things. Just keep us in the loop, would you?
Sure.
You may continue. Thank you.
Great. So again, additional barriers to reaching these goals. There are myths related to the family court system. I'm going to go into some of those in more detail shortly. Personal experiences, you've heard a lot of them. Are these systemic issues that we're talking about on a statewide level? Are these individual cases, individual issues? And are we talking about really dismantling or restructuring an entire system based on any particular individual? I think there's a lack of understanding of domestic violence and the effects of trauma, and how victims present when they have either been abused domestically, domestic abuse by their partner, or sexual abuse, or stalking, gender-based biases within the system, inappropriate access to language access services, and lack of necessary resources. We're tying our judges' hands. That we have situations where kiddos, the safest option for them, if a parent is to have parenting time with that kiddo, is supervised visitation. We're tying our judges' hands because we have one safe supervised visitation center left in this state, and their funding, I believe, ends in December of this year. One safe supervised visitation center left that uses a metal detector, that follows best practices. So, and that center is in Stratford County, and they accept cases from all over the state, not just Stratford County. But who from the North Country is going to drive to Stratford County to be able to use supervised visitation? And so, what does that mean for our judges? They very much want to. I mean, you can read in the statute what the goal of RSA 461A is, to support frequent and continuing contact when it's safe to do so. And sometimes that's within the supervised visitation center. But what if we don't have supervised visitation centers anymore? What is the judge going to do? The judge is going to balance no parenting time for this person or unsupervised parenting time for this person. And neither of those are good options. So we really do need to think about what resources are available. Batterers Intervention Program.
Batterers
Intervention
program.
Yes. So then I want to talk a little bit about the myths that come up frequently in Children and Family Law Committee. I believe they've been raised in this committee as well. We talk about a lot with 50-50 shared parenting, and that parental rights and responsibilities, the default automatically goes to mom. That's not true. In fact, mothers are more likely to lose custody of their children when allegations of abuse are made against the father.
Could we have some
I
documentation?
do. I have the study for you.
You are very quick.
I have the study.
Thank
for
you.
So I do want to acknowledge that that moms in family court, it's not automatic, it's not the default, and oftentimes when they do raise allegations of abuse, whether it's physical abuse or sexual abuse, that they are more likely to lose custody of their kids, even if there have been findings of abuse, even if it has been proven that their allegations are true against the father committing abuse, that they are still likely to lose custody. And then gender bias against women does exist within the system. You have, I mentioned that victims are often experiencing effects of the trauma, and that spills over into the family court case. They are in court at a table next to their abuser. They are re-triggered, they're triggered. They are often emotional. They are unable to present their case, particularly if they're self-represented, because that's what trauma does. When I talk about biases, I think the opposite is true. If somebody is alleging abuse and judge sees that person and they have an idea in their head of how is a victim supposed to behave, how is a victim supposed to testify, oh, they're supposed to be crying, oh, they're supposed to be hysterical. Well, this person isn't doing any of those things. So did it happen? Those kinds of biases we are constantly training the judges on, that we have to let go of these biases. But for the parent or the mom that is presenting in a particular way, that is presenting as a typical victim, that they are hysterical and emotional and unable to present their case, and that hurts them. Because the abuser oftentimes is put together, is able to articulate, and that's part of the continued abuse. And it does not bode well all the time for moms in those cases, and that's where the statistic comes in, because they can't present well.
I'm going to ask Representative Ball for her question because I think we're trying to, as presented. Thank you.
Thank you, Chairman Pearson, and thank you very much for your testimony. I'm having a little bit of a hard time that this bias I know that you say these are myths, but wouldn't all of this still be true for the father who's being accused unjustly, that he might also present as a little bit upset and maybe even aggressive in the courtroom because he's afraid of losing his children?
If the father has been accused, thank you for the question.
I'm saying even if the
Representative.
father has not been accused, even if he believes it's a false allegation
So-
or it's going two ways, I'm saying it's a very emotional time in the courtroom, and shouldn't both parents be given some degree of latitude of understanding that this is emotional, the children are involved, maybe one or both didn't ever even expect to be in the courtroom for a divorce. So I'm kind of a little concerned when we keep referring to females as the only victims in the courtroom. That's just my opinion. And I don't want to belittle domestic violence, but I've also heard, and just correct me if I'm wrong, but wouldn't also emotional abuse and verbal abuse be considered not just sexual and not just physical abuse? Isn't that all abuse?
Thank you for the question and for making that distinction. I would 100% agree with you that emotional abuse, psychological abuse, financial abuse, all of that is abuse. Unfortunately, that is not the definition of abuse under New Hampshire state law. So it does not include those factors.
Do you have the RSA on abuse statute?
I don't have it with me, but I can tell you that it's sexual assault, physical assault, harassment, interference with freedom, which would be stalking, destruction of property, and abuse of pets, I believe. I'm sorry? Oh, and criminal threatening, thank you. I left that one out.
Thank you very much for
Thank
that
you.
clarification. I very much appreciate it.
Thank you. So yes, I do want to acknowledge, also to your point, Representative Ball, that I'm here because I work exclusively with domestic violence victims, primarily who are women. Statistically, women are making more reports of domestic violence, and statistically, I think it's one in, I don't actually want to quote the exact number. I can certainly get that for you. That is not to say that there are not male victims of domestic violence, and we do represent male victims of domestic violence. But for the cases where we are providing representation, our clients are primarily female. But there are cases that do not involve domestic violence at all in family court. And certainly, even in those cases where there is no domestic violence, yes, emotions are going to run very high. And you know, it is it is a difficult process. And yes, everybody should be given some grace in the family court system because, and there is a recognition of that in the statute, I think, that there should be recognition that this is a difficult difficult process. And the goal is to make it so it's not adversarial. Unfortunately, that is not always how things shake out. So, and again, I'm talking about protective mothers and the experience because again, that's what you'll see in the report that I provided, but also this is our primary client population, that protective moms are often seen as hypervigilant and overly protective. Strides that they take to protect their children when a system fails them raises allegations of parental alienation syndrome, which is not in fact a syndrome. It is oftentimes used as a tactic by abusive fathers to further abuse within the family court system because they're no longer able to do that within the confines of their home.
Yes, Representative McMahon.
Thank you, Mr. Chairman. Specific to that subject you just brought up and what we had testimony from the Attorney Chandeleras, judge would decide the rules of evidence or relevance. And as stated, that parental alienation syndrome is not a recognized syndrome. And I just to defer a moment, is that by what higher authority would it be a recognized syndrome?
If it was in the DSM, which is lists all of the different syndromes and mental health,
As of which edition did it come in?
it's not in there.
It's not.
It's not.
Okay.
It's not.
Okay, then the follow-up one on.
Follow up.
Thank you, Mr. Chairman. Then on that subject matter, under the current environment of the court system, are the judges not eliminating that under relevance and evidence because it's not a recognized syndrome?
Thank you for the question. It is my experience that that has been raised in family court, and whether or not somebody calls it parental alienation syndrome or calls it parental alienation, that those facts are in fact considered in some decisions.
Then one final clarification then.
Yes.
Thank you, Mr. Chairman. This is going under when we have our discussion as a committee on what rules to recommend. Is this then an opinion on a statement made, in this case, by one party, not necessarily saying male or female, but just one party, that then it is the scarlet letter of PAS is put on the interpretation of that statement versus what the facts are?
Thank you for the question. I think that can absolutely play out that way. I think that one parent, for example, could be talking to the pediatrician, could be talking to DCYF. They're doing that because they're scared that something is going on with the child, because the child has either told them or the child is exhibiting symptoms of abuse or neglect. And so they're taking these steps to protect the child. But to the other side, the person who is being accused of doing those things to the child can raise these, well, she just doesn't want what the other parent who is doing these things is saying these things because they don't want me to have time with the kid. I'm a great parent, but they don't want me to have time with the kids because they're upset with me about X, Y, and Z. And so the court considers those things and considers, oh, maybe this parent is doing those things because they don't want the other parent to have any time with the kids. And
How
that
would the
narr-
court determine that? In a criminal court, you've got all your investigators and everything. What do you have in family court?
That's an excellent question. Thank you for that, Chairman Pearson. Oftentimes in family court, the only evidence that you have is the party's testimony, and that is evidence. I think oftentimes we're very much looking for where's the document, where's the police report, where's the medical record, which is a whole other issue. But where are those things? And oftentimes those things aren't there. You just have the testimony of the parties maybe some witnesses, and that's it. And the judge needs to make a determination based on who they found was more credible. And again, that goes into my discussion on presentation from either parent.
Yeah. This can get a little dicey, I think,
You are correct.
and we need to improve this. So we need to think about how to do this. Not right now, but we do. Yes, yes, Representative Macbeth, making a great effort in spite of.
Thank you. So I just wanted to point out that there are statutes, and 461A 6 that was mentioned by Attorney Shandelis earlier today. It specifically has like 11 criteria that the courts to look at that the legislature has come up with, and at least 2 of them, if not 3, have to do with which parent will promote the relationship with the other parent despite harm to them. So this stuff about alienation or parents that are making allegations, it is addressed in the statute, not only in those 3 separate sections under parental responsibility. But I can't speak to that right now, but I will provide that to the committee. I think that's what you're looking for, is what standard, like of best interest. But so the testimony on parental alienation, while she's correct, it is not a syndrome listed in the DSM number 4 or any, but it is the legislature has provided criteria for the court to look at in that area. Thank you.
So, thank you. So I know I've put a lot out there and given you a lot of information. So we talked about in 2004 what was the intent of the legislature? What was in the statute? What were the goals of the family division at that time? Kind of what is happening currently from our experience in our statewide practice. But I know you want some ideas about what do we do from here. So I was hoping to, and I want to keep it positive, and I want to tell you about all the good work that is happening, because there is a lot of good work that is happening, because people are recognizing that these things are happening within the family court system. And what can we do to correct it? Obvious answers are more funding and more people to do the work. This is the system that we have. And, we're not looking to dismantle an entire system or start from scratch. So what can we do with this system? How can we enact change within the current system that we have? So there are access to legal remedies. People who go through the court process and are not happy with the orders, there are multiple stages along the way where somebody can try and get a change to their order. So let's say somebody gets an order, either a temporary order or in their divorce case, or a final order in their parenting case, and they don't agree with it. They think the judge just completely got it wrong. Either they made an error based on the law, or they didn't understand particular facts. They can file a motion for reconsideration. They have 10 days to file a motion for reconsideration. From there, if it's a final order, they can file a New Hampshire Supreme Court appeal. They can access the Judicial Conduct Committee and evaluations that are online. I think rightfully so that there were some recent issues within the family court system, and I know you have heard from the public on these issues, and those issues were corrected. Those judges are not sitting on the bench anymore. So there was a response. It may not have fixed the entire problem, but it wasn't ignored. There was a response. And respect the work that's being done. I think everybody is genuinely well-intended, and we are not perfect people all the time. It's an imperfect system, and we're humans, and we make mistakes, but we are working hard to address those things. In 2021, at the end of 2021, I'm sure you're all familiar with the situation where a woman was denied a final protective order out of Hampton Family Division. And several weeks later, her ex-partner shot her as she was leaving her work in Salem, Massachusetts. And that was a tragedy. And it's unfortunate that a tragedy really pushed us to enact all of this change. But as a result of that, there was an internal review within the family division. There was the New Hampshire Supreme Court set up a task force on domestic violence cases in the New Hampshire judicial system. I sat in on that task force. As a result of that task force, we produced, I think it was a 61-page report with multiple recommendations. I am happy to say that that is not a report that is sitting on a shelf, that we are enacting those, we are making those changes. We are looking at those recommendations. The governor reinstated, as a result of the task force, the Governor's Commission on Domestic Violence. They are working diligently to make changes. There was a call for increased resources for civil legal aid. We started a Manchester domestic violence clinic as a response. We are on site every Thursday at the Manchester Family Division, on site representing victims in their domestic violence cases as they come to court. So that is on-demand, on-site services every Thursday, and we started that back in October as a result of the task force report. I think we need data. There needs to be a better way to track case outcomes so we can see, are these one-off cases? Is this a systemic issue, or is this one particular case, one particular catchment area? We need to look at perhaps exploring the implementation of civil domestic violence courts within the family division. And I have a handout for you about what civil domestic violence courts look like. So that, you know, and this is in line with one judge hearing the similar types of cases. So the same judge hears the domestic violence case, the same judge hears the parenting case. We need to have additional judge training on domestic violence and the ACEs, which is adverse childhood effects. And more consistency across the state in how courts and judges are applying court rules and protocols. And one of those programs, which is produced by the Battered Women's Justice Project, is called the SAFER program. And it enables professionals and judges and courts to look at these cases in a similar way and to ask similar questions so that there is consistency across the state. So a case that's being heard in Keene is being handled in a similar way to a case that's being heard in Ossipee. And I apologize, I only have one copy of that for the chair. I wasn't able to make multiple color copies, and it requires color.
Do we have a color printer on the 4th floor? It is so huge, but it's still black and white, okay?
We do have.
Oh, we do. We don't. Okay. I'm sorry, we're
No.
just, you know.
That's fine. And I do just want to address one additional, and then I'm happy to take any questions. A question that came up with Attorney Chanelaris is that I think it was, I don't know if it was specific to the family court system or just 50-50 shared parental responsibilities. Could that be used to weaponize the system? And it is my opinion, based on the work that we do with domestic violence victims, that yes, the process can be weaponized. The family court system can be weaponized. Shared parental responsibility, or 50-50, can be weaponized, because oftentimes in domestic violence relationships, the most dangerous time to leave is the most dangerous time for a victim is when they are making efforts to leave that relationship. And so that includes filing for a divorce or seeking a protective order. So if the jumping off point is 50-50, and I've said this in prior testimony, if the jumping off point is 50-50, that is something that will be used by abusers to keep that victim in the home. Because if that victim knows that they have been abused and that their kiddos have been abused, and that there's potential for that child to be abused outside of their care, if they know that the court is likely to grant you, the abuser, 50% of the parenting time, what incentive does that victim have to leave in that case? Because they won't. Because at least 100% of the time, if both parents are in the home with the kiddos, they can see what's going on. They can intervene. They can protect that child. But if it's 50-50 and they know that, and the abuser says, if you leave me, you know what's going to happen? I'm going to have Johnny, I'm going to have Susan 50% of the time, and there's nothing that you can do about it. That is terrifying. absolutely terrifying because they will want to, and then they will want to stay. And that cycle of abuse will continue. And parents will be hurt and kids will be hurt. So 100%, in my opinion, based on the work that we have done on a daily basis across the state on behalf of victims, yes, the family court system can be weaponized. Yes, 50-50 custody can be weaponized. Thank you.
Thank you for your testimony, and I have not heard such beautiful round O vowels since my last trip to Wisconsin and Minnesota. Are you a native New Englander?
I am, yes.
And yet your O vowels are so wonderful. Sorry, that was just an aside. Any questions? Any questions? None. Thank you so
Thank you.
much
I will just hand
for
out
the
materials.
just to the end of the row. Yeah, that's good. An extra, he says. Okay, that goes to the well, we're now starting to look at pink cards left over from last week. And the chair recognizes Melinda Nicolosi. Are you two people, one selection, count says? Because I think I remember Renee Martinez. Are you testifying together? I can't hear you. It still needs to be on.
I'm going to testify before her case because my case leads into her case.
You know what? I still cannot hear you.
I'm going to testify before her because
Okay.
my case leads into her case.
Okay, then
If
go.
that's- Okay.
And you are,
I'm Renee Martinez.
okay?
My sister Melinda Nicolosi is in a litigation in Derry Family Court in New Hampshire.
Okay, start the clock.
My
And this
sister's
is
gonna
one case, right?
It's two separate.
It's two separate cases.
Two separate cases. I have a stalking case that led to what happened in my sister's case.
Okay, let's hear your case.
Okay, so thank you. On May 13th, 2022, I obtained a no stalking order against the ex-boyfriend of my sister, this ex-boyfriend has custody of her son. On May 16th, 2022, the ex's lawyer sent my sister an email telling her that because of my protective order against his client will be suspending her parenting time effective immediately, and reminded her after that she could not file a contempt against his client for interfering with her parenting time because she's defaulted out of the case. And the court advised her at this point that she cannot file motions and has refused all of her motions that she's attempted to file, including contempt motions. On June 2nd, 2 weeks after they put in their motion to suspend her parenting, the judge granted their prayer to, in quotes, suspend mother's parenting time and Skype calls until the sister's protective order is dismissed. The judge did not modify the prayer. He just wrote granted underneath that prayer. At this point, he was predicting that my case was going to be dismissed, or he knew that my case was going to be transferred down to him. Okay. Okay. I believe there's been extreme bias in my sister's case, and when there was a warrant issued for my sister's arrest because she was protecting her immune-compromised son from what his former doctors advised her could seriously harm or even kill her son, she had a warrant they obtained a warrant based on a lie that they filed with the police. She can explain more about that. In my stalking case, was petitioned in Manchester. I didn't tell my sister, I didn't tell either of my sisters that I was filing the petition because they were afraid. They were afraid that what ended up happening happened, and even then some. Once I obtained the petition from Manchester, when they granted me the stalking order, that's when I told them. I had tried many things. My sister had called her, emailed or texted her ex, warning him that if he didn't stop harassing me or stalking me, he stalked me 4 times, that I was going to do something. I sent him. I asked her to email him and tell him that I would do counseling with him to find out what was underlying why he felt uncomfortable around me, as he claimed to her. And I sent a cease and desist order for him to sign. He refused. I sent him and his attorney a letter, an agreement letter, refused. I did many things to try to avoid going to the court, but he kept on harassing me. And I finally went and asked Manchester. They gave it to me, and his attorney put into Manchester court that if they didn't transfer this case down to the same judge that has been exclusively overseeing my sister's case, that it would take at least a 3-hour trial for Manchester to hear my case. And so he basically scared Manchester into sending my case down to the judge that's overseeing my sister's case, who I feel has been very biased, and has silenced me throughout my sister's case while I'm a key witness and have been present at every event almost that has happened since we lived together, since my nephew was in the oven. So okay. Oh, I'm sorry. Okay, so let me just catch up here.
I'm giving you a double portion of time because there's 2 of you, so you do have a little bit more time, but not infinite. So these pauses are counting against your time. I just need you to move on.
Okay. Basically, my case was moved down to this same judge, and he refused me all of my witnesses. Basically, he put things in the orders that after making the corrections in the hearings, were still reflected, even though he said he was making the corrections. They were still reflected in the final order. He dismissed my case. And during that time, I asked the judge to modify the order because he was hurting a mother and child when they didn't do anything wrong. There was nothing that my sister did, nothing that the child did. It was basically to protect the man from potentially violating my order, that her parenting was suspended. And this continued. My case was continued 3 times, postponed and continued 3 times. And it went on for about 250 days, and I kept asking the court to please modify, and he wouldn't modify it. He just kept continuing it as requested by the defendant or her ex. So I'm gonna lead you into my sister's case, because her parenting was not only suspended but ultimately terminated as a result of my order protecting this man.
And I'm going to ask you for specifics. If you say the witnesses weren't allowed to testify, what witnesses? Why were they not?
I had listed about 16 witnesses.
So this is in the document you gave us.
No, the document you have is my sister's.
Okay. Are
I
you
didn't
going
give you.
to
I'm going to
provide
email.
us with something?
I'm going to email everything,
Okay, good.
supporting everything I say.
Because that's the only thing that will help us as we're considering it. We're not retrying the case.
Yes.
A broad generalization is of no use. So you
Okay.
have to give us specific details. If a judge said no, did someone object? What was the objection? What was the judge's answer? What did you do next? Those are the things that will help us. Okay?
Okay. So when my case got moved to Manchester, I gave many reasons why it shouldn't be. My case was a civil case, and this judge, after admitting that he was not allowed to use any of his prior information knowledge of me in my sister's case, he wouldn't move it back to Manchester. Manchester mistakenly moved my case into a different jurisdiction, but he held on to my case, and
Was the change of venue objected to officially on the record?
many times, motions and in hearings.
Okay. Again, go specific on that if you can. Chair recognizes one of the clerks.
Thank you, Chairman Pearson. Thank you for coming and testifying and for taking my question. Which court was it moved to?
Derry District Court.
Thank you.
You're welcome. When I submitted a motion to violate the defendant, on August 29th, I had submitted three motions. One was for him to release who he had tracking me on Facebook, and another one was because I had thought that the order said for him to attend counseling. One was to order the counseling, and the other one was to violate him. Two of those were supposed to be addressed on August 29th at our pretrial conference, and the judge first said he wasn't aware that they were, and I showed him, and he said okay in the case summary or the order, and he said that he wasn't in that hearing. He refused to address those two contempts, and he had already decided before that hearing that he wasn't going to address the motion to violate. And I asked the judge why he wouldn't be addressing that motion to violate, because that would take care of both cases, what was happening in both cases at the same time, and resolve probably both cases. And he didn't give me a reason. He postponed all of the motions to the final hearing, which was delayed over 100 days after that, I think.
We now have 30 seconds to bring this to a close. Is that both people?
Okay.
This is both of you. I gave you 10 minutes. You have 30 seconds now to conclude your testimony. If you are not providing us the specifics, then email us. We have your written testimony, and I will give you 30 seconds to summarize it.
Hi, thank you for having this. Thank you very much.
Okay.
And I guess I have just suggestions I would like to ask. I guess when you're a defaulted party, how to I guess become not defaulted, because they're holding that against me, and using that in all my motions, everything I submit to the court. It's everything's always
Okay, I'm
based-
going to stop you now, and I will give you the opportunity to revise your testimony because it is not helpful to us.
Okay.
That's not an insult against you. It does not in any way diminish what you're going through, but it's not helpful testimony. Because when it says, the judge has not afforded me the right to present evidence, what kind of evidence? No, I'm asking you to write this. Those are specifics. Ignoring all the rules of evidence, which rules are they? Don't answer me. Put it in your new email to us. He has denied me the right to ask for discovery. Do you have a copy of that motion? When was it presented? Were you representing yourself, or did you have legal counsel? We need specifics, because right now these are generalizations that do not help us make changes. So as I've been saying, and I know some people are tired of me saying this every week, that is the testimony that will be helpful. So I'll give you a shot at doing a do-over through a much better prepared, detailed testimony.
Okay.
And that will be good for us because I think you're onto something here.
Okay,
We
so
just
I
need to
do.
know.
I will
So
have
I'm
it.
going to now, and I'm going to call some other people, okay? So we'll be looking forward to it.
Thank you.
I think you got a lot of stuff
Would I
there
get
that can
an
help us.
email? Do you have an email?
Okay, thank you. And now I'm going to call Michael's, is it Michael Spite or Spate? Spate. Please be seated and turn on your microphone. And remember, you have 5 minutes.
Yeah, first I'd like to say that, all that stuff about domestic violence and everything and child alienation. My ex-girlfriend went to 3 different courts and tried to get restraining orders on me, and not one of them stuck out of Derry District Family Court. I haven't seen my kid in a year, and I've been paying child support. And I'll tell you what the judge did wrong there is she put in a motion to file for to have it dismissed and moved to Massachusetts in July of last year, and it was denied. Jurisdiction was in New Hampshire. And then another judge came in November, which I still hadn't seen my kid the whole time, and he heard the case on an oral motion, which is against the law because you can't hear the same motion with the same evidence over and over again. New Hampshire Circuit Family Court Division 126 motion for reconsideration. She didn't preserve her right for appeal. And the second judge overheard it. And then if you want to go into appellate court cases, you got Roster, Kelly versus Kerwin out of North Carolina. Same issues, same motion. Second judge can't hear the same motion as the first judge because it was already denied. And then not only that, it was an oral motion to dismiss. And he was supposed to give me 30 days to prepare for the motion. He heard it that day. So what I'm saying is, if it's all up to discretion of the judge, everybody's screwed.
Do you have those specific things that you've just mentioned?
I got them all on my phone. I can print you out my appeal that's in the Supreme Court right now.
I would like that much better than having your phone. If you could print.
I'll email it to you.
If you
not
could do
only
that.
not only that, like if, like I haven't seen my daughter in a year. This is my daughter. That's me. And I'll show you another picture of my daughter. Not one allegation of abuse. I haven't seen her in a year.
If that could be printed out and sent to us, this would be very specific kinds of things.
And
that
there's
we could
more.
look
And
at.
there's more. She got caught lying 4 times. She said she lived with me 5 years in Massachusetts. Then in Derry, I'll send you the transcript. She said I didn't have anything to do with the baby 4.5 years of her life. She lied in all transcripts. Her lawyer lied, truthfulness of a statement, perjury. Not only that, she kidnapped my kid and took her to Massachusetts. Nobody did anything about it.
Okay.
And talk about child alienation. I haven't seen my kid in a year.
Okay, chair's going to ask the vice chair. She's got a question.
You say your case, a domestic violence case is before the Supreme Court?
No, there is no domestic violence case. She went for 3 restraining orders and they all were denied.
So if I could, what is the case that's before the Supreme Court?
Jurisdiction. Derry. We lived in Derry for a year. I bought a house in Derry. We lived there for a year. That's the baby's home state. I filed for custody 3 days after she left. She got Massachusetts to intervene, which is against Massachusetts law and the Department of Justice laws.
Okay, thank you very much.
So Massachusetts put in a temporary order until they got the parenting petition from New Hampshire. I sent it to the Department of Revenue's lawyer to give to the judge. He withheld it. I have that email too. I'll send you all the evidence.
That would be helpful.
What I'm saying is, if people can't get it right, and straighten out the system, people are going to find a new system that works for them,
Understood?
right?
Thank you.
And that means the people above them, the people that oversee it. So right now, what I'm doing is I'm putting in I'm getting together a visitation enforcement agency, not state funded, not federally funded, that's going to help people get visitation for their kids.
Okay, we're going to bring it to a close because are there any questions from us on, sorry, can I have a, Michael?
SPEIGHT.
So yeah, that'd be helpful. I think we've come to a conclusion here. Yep, we have, and we've got the specific.
That's
things that are
fine. What are you
coming
going to do
us.
with all my paperwork? Just read it and shred it?
What would you like us to do with it?
I would like you to do something about the court system.
Chair recognizes Robin, is it Partel? Patello, okay. Sorry, I had some good training on O's a minute ago, so I got it now. Thank you. Robin
Thank you.
Partello.
Thank you, Chair. Robin Partello. I am a resident of Nashua, New Hampshire. I have been in the Nashua Family Division for 4 years. My case actually just came to a conclusion, but it's not through the appeal process, so I'd prefer not to get into specifics. I have had interactions with
Excuse
the-
me,
Yes.
you are going to have to get into some specifics
Well, I
if the
will.
testimony is to be helpful to us.
Correct. Just not
Generalizations
of my
don't work.
case, specific details.
Okay, all right,
I
we'll see
have
how
a-
it works.
I have a different angle to present.
Okay.
So I've had interactions with the Judicial Conduct Committee, which I was successful, the Professional Conduct Committee, and the GAL Board. My issue to present here today is about the process. And the individual before me actually gave me a pretty good roadmap because what he was saying was correct. When you go into a courthouse, you sort of have expectations or there's clear guidance. And that's the problem with the family court. And what he's saying is that a judge held a hearing prematurely. And I see that happen all the time. And it is scary because the process in family court is you go in for your first appearance, then you have a temporary hearing, then you have a scheduling hearing, then you have perhaps motion hearing, then your final hearing. When you go in for the scheduling conference hearing, you are expecting to set dates for discovery. What the court is doing is they call it sua sponte or on its own. They have a motion hearing, and I wouldn't have believed it if I didn't read the transcript myself, but I've seen two different courts completely strip a parent of their parental rights in this status conference. And I listened to the attorney object. It was a due process violation, and the courts still do it. And that's my issue with discretion, is if I say to you, you know, you have to do something in a reasonable fashion, what does reasonable mean to you? Because if it has a sense of urgency, I say 24 hours.
It would be helpful in those cases that you alluded to if you could email us with specifics, when, what judge, because I can see examples when I would have ruled that way. I can also see examples when that was an incorrect ruling, but I can't decide about what you've said because I don't have enough specifics. So to be helpful again, if you would give us that and you can email the committee, that would open up some possibilities for us.
Excellent. I have a transcript and I'll point out to the specific paragraphs so that you guys don't have to go through a 200-page transcript. It's
Thank
very
you.
difficult. And my last and final point is the process on GAL PCC issues. If you have an issue with your GAL, the court says go to the GAL board. But what you don't know is that the GAL board will not hear a complaint about a GAL in an ongoing case. My case lasted for 4 years. I could not file a complaint. I filed with the PCC. They said go to the GAL board. Now that I can file, guess what? I have a statute of limitation issue. Now I can't file. So essentially the GAL board is really tying the hands of litigants to file a legitimate complaint. And that's all I have for you today.
if you could give us a one-pager about what you just said about GAL, that would be helpful too. Because we
Okay.
could look at that specific issue of how do you complain against a GAL? Apparently only when it's too late.
Yeah, and the other issue is that you're sworn to confidentiality on all of these complaints that you make. So in my judicial conduct committee complaint, I was not allowed to tell a soul that I had complained about this judge. But what she was allowed to do was go back to that courtroom and train a new judge to take over my case. So clearly I can't prove it, but in the mind, I would think that there's a bias from that judge. And there's also the issue on judges. I noticed that there's a shortage, and I have, sent emails to some attorneys that I've dealt with that are just amazing and would be amazing judges. But the problem, and I don't think you would see this, is old school attorneys don't type their own stuff. They have secretaries. They sometimes struggle with attaching something to an email. If they become a judge, they're a one man or one woman show, and they don't have the capability of drafting all of their orders. So perhaps if you look at the process, it might make sense to attract new judges, to offer a law clerk or a secretary, somebody who could assist them, because in Massachusetts, there's layers to get through. You go through a case manager, all of these layers. So when you get to the judge, it's not such a heavy burden. In New Hampshire, we're going straight to a judge and saying, solve all of our problems. If we're pro se and we don't have child support, can you help us figure out how to do it? It's just too much on the judges. And I think the process can be expedited and, more beneficial if there were layers to assist that judge.
Okay, thank you.
Thank you.
I hope this will be in the written, wow, you're good. Look at that. Will be in your written testimony too, because I can see a couple of things right now that'll be very helpful as we start to consider things. So thank you so much.
Thank you.
Chair recognizes from Derry, New Hampshire, it looks like TJ or TT? TJ. Oh yeah, there it is. Okay, got it. And
Thank you. Thank you, Chairman. And
yeah, we before you are allowed to begin, we would like your name, please.
TJ Moonan, Moonan.
Moonan.
N. It's like Noonan with an M.
Spell it again, please. M.
Moonan.
Nan.
Yeah.
Okay, Mr. Moonan, thank you.
Okay. I have a daughter. She's 32 years old. I've seen her a total of 70 minutes in the last 25 years. I've been working with non-custodial parents, or dependents, as I like to call them, to help them to reestablish a relationship with their children. And I've seen a lot of good things happening with that. It's amazing what I've seen in my work. I don't have any qualifications. I'm not a paralegal or a lawyer or anything like that, but what I've seen through my own education is there are a lot of discrepancies that don't make sense. The courts are given financial incentives to collect child support, and the agencies are given incentives to remove children from families. But there's no money given to visitation enforcement, like Mr. Spate was talking about. I'm working with state senator and a couple of representatives, and a member of the executive council. Sorry, to create a visitation enforcement agency here in New Hampshire. I'm working with other people in different states to do the same thing there. It's very confusing. I got divorced in 1992, and I went into court thinking I knew everything, and I didn't realize that, you don't get a lawyer. If you can afford a lawyer, you don't get one. And there's no jury trial. I got convicted twice for being behind on my child support. No jury trial or anything, and it's just you pay it or else. And I spent over $100,000 on child support without having any contact with my daughter because of false allegations. my ex-wife accused me of something, and she didn't have to prove it happened. I had to prove it didn't. I don't understand that at all.
Do you have a date when that took place?
That was our visit stopped in 1998.
Because it would be very helpful. Just for the audience, we are not receiving any more pink cards today. We are already gone over noon. So if you want to fill one out for next week, go ahead. It would be helpful if we could have specific details.
I can give you details. It was in Massachusetts. I can give you the document.
It would need to be written out and sent to the committee or
Absolutely.
and so on.
It was in.
Oh, it was in
yeah.
Massachusetts.
I live in Derry now, and I work.
Okay, thank you. Do you have a New Hampshire case that you're presenting before us?
No, I just wanted to get the information out there and
Okay.
find out why, if you can answer this, why is visitation not in the best interest of the child with both parents? It doesn't
Okay,
make any sense.
we would not know that. It sounds like the decision was made in Massachusetts.
Well, no, it's everywhere. I mean, there's no visitation enforcement agencies anywhere.
Okay. And you had said that you have been speaking with an executive council member and at least.
Senator and a couple of.
Okay, if you could type that out, who you talking with? Because maybe we want to talk with them too.
Specifically, mostly with Senator Abard, Kevin Abard,
All right.
and along with Erica Leon
Uh-huh.
and Janet Stevens.
Okay.
So these are the people I've been working with.
Yeah, good. That'd be helpful.
Okay.
We may want to ask them this. Thank you.
Unfortunately, Kimberly Rice
I know.
wasn't available.
Yeah, she's getting better. She's healing up.
Mhm.
So thank you, sir. Appreciate this is what we need.
Okay.
And got a couple cards left from Vivian Gerard, who has been patiently waiting out there since the crack of dawn. Come on up.
Thank you, Chair and members of the committee. I just wanted to bring up a couple of things that have come up this morning with Catherine. She said that a lot of different facts that I think are very misleading. And as you know, Chairperson, that I've been up here several times. And I do actually have a letter from the Judicial Conduct Committee. It's taken many, many times, many tries on my case, and some of you are new here based on my case. So I am the Silva v. Silva case. And in my case, I've been to several different bad judges. I've unfortunately, at the very beginning of my divorce, I do believe that there's a problem with the Good Old Boys Club Committee, where my opposing counsel's attorney was on the GAL board, so wasn't the judge. They were in cahoots. Later on, I find out that my my ex's new attorney was the clerk for the other judge that was taking over my case. And I do feel that.
Did you raise conflict of interest issues there?
You know, I did do a Judicial Conduct Committee complaint again. And as many of you know, that I'm in cahoots here with Mr. Mittelhoser. I've been talking to him for years. I've been telling him on many different occasions where I feel that the rules of the process were broken, the court rules, the due process was not being followed. There were changes in the law and procedures. There was never any offer of proof. They keep talking about the discretions that the judges have, and I believe that they are using the judicial discretions inappropriately. I
Okay,
believe
all right,
that.
again, specifics.
I have them all here.
You got them
Your-
all, and we're going to get one of
Yep,
your
I'll give you the
beautiful-
copies of
yeah.
it. I'm trying to scratch the surface of it because, again, I had 29 hearings. I had 5 Supreme Court appeals. My biggest problem is I had 2 judges that both got disbarred. Well, one was a marital master, which we no longer have. It went to the court. They said that they were not going to. First of all, I was told that I had a hobby and to go out and get a real job, that they took away child support and alimony, which they had no right doing. That is to support the children. They took away my alimony because of my business. There's been a lot of judicial discretions, and she even said on the bench that she should not be making this ruling without looking at the law that applies to alimony. But she said, regardless of the relationship, it doesn't matter if it's a business deal, you're losing it. And after going to the Supreme Court 5 times,
Do we have a place cited where somebody could go back and hear that said?
yes, yep,
That's
actually,
and you've transcribed that and referenced it in your notes.
yep, actually, the other problem that I do have is the first comment that I had received from the first judge, that was not on transcript, but I do have witnesses that have heard it. The other comments, which again, I have a judicial conduct complaint here that Marital Master Delbra specifically said that he was not going to fix the remand orders that came from the Supreme Court because I was a thorn in his side. He said that he did not want to reopen the can of worms on my case because it's been so many years. So even though they had very explicit orders from the Supreme Court to fix my case, he said he was not reopening that can of worms.
Was that conveyed to someone who works in the Supreme Court office?
You know, that's a good question. So it was heard by the Judicial Conduct Committee on record. We have no transcript, no audio that has that specific saying, but Robert Mittelholzer, and it also says here, these comments were confirmed by the committee upon its review of the audio recordings of the above hearings. So as I had sat before you many times to tell you that there's been so many processes where are not being followed. For instance, like I said, the Supreme Court gave them explicit instructions. I have the Supreme Court ruling here that says exactly what is due to me and my children. It went down to the trial court. The trial court said, nope, you don't deserve it. Again, said on record.
Okay. Did you then rat that court out to the Supreme Court?
I did.
Okay.
I went again 5 times to the Supreme Court. Again, I got another remand that says I gave you explicit instructions to fix this case. And you know what the next judge did? He said, I am not reopening this can of worms. So it's been a trend where I was biased up against at the very beginning. And I feel like the court is that playing field where otherwise these people would be put in jail. For instance, my ex originally had given me a false DV.
30 seconds left.
Sorry. False DVs, false police report, false court cases, false DCYF reports, criminal threatening, conspiracies. I even had a DV put against me, which when I went into court, the judge said, he's the one that should have this. He's preventing your business. He's stopping your funds from coming in. He's shutting down your booking engines. He's doing this, he's doing that, and continuing. So he actually turned around and weaponized that restraining order that the judge put on him to turn it around on.
And we will be looking forward to getting your documentation of all of this, because this is the kind of stuff that we need. Not in a specific case, mind you, we can't do that, but to say, whoa, if this kind of thing is happening and somebody else has given us documentation, maybe we got something that needs to be fixed here. So, okay, I've cut your mic off. So if you would, if you have copies, please give them to the last one in the row. And if you don't have enough, then you know where we live. No, you can't. You're finished. Thank you. So if you got handouts, we got it. We'll take them. And you used a rainbow of such beautiful paper, as I recalled. I know. And whilst you're doing that, we're going to call Robert Tanguay. You got 5 minutes. And you can start on this end. And you're going to need to turn the mic back on. as I had killed it.
Boom. Hello.
Hello.
My name is Robert Tangwin. I've spoken before this committee before,
Yep.
and I do appreciate it. I'd like to actually honor your work. The Honorable Miss Gay for kind of putting this together. I've spoken with the Honorable Mr. David Beckford, who drafted in 2005, was part of one of the drafters of 461A parental rights and responsibilities, which is very important. I want to take this time to kind of deflect some of what is going on, especially with the lady who spoke for 45 minutes, without any substantiated evidence. The courts are not, the family courts specific, are not working, following their rules. One of the first rules in first appearance is that it must be before a judge in the family court. That is Rule 211, first appearance. That did not happen in my case, and it does not
Okay, if you
happen.
could hold up for a minute, I want to make
Yeah.
sure this gets into our record, and we got a little paper jam up here, but I'd like this specific thing.
Okay, so
you
may I
just
reserve
said
my
to be
time, sir?
typed in when we
May
got
I
a
reserve
minute
my
here.
time, sir?
So, yeah, we're stopping the clock
Thank
on
you, sir.
there. Yeah, I'm good that way.
I appreciate it.
Okay,
And we're gone.
there we go.
Okay, so 211 first appearances in the family rules. You guys need to read the family rules. It's not that hard. It's not that complicated. Rules aren't magic. You guys know 'em. You guys know laws, and that's what you do. And it's a very important part of the foundation of our democracy and the reason why we're not ripping each other apart. What's happening when the rules aren't followed is that we're ripping each other apart in family courts. So first appearance, you must have a hearing before a judge, and you can read, I could read it word for word, but basically they're supposed to order mediation to prevent this. And they're saying that, oh, mediation is available. In my specific case, a parenting petition was not filed until September of 2022. And then I went through the first appearance, and then the domestic violence was filed against me fictitiously to gain strategic advantage in the court case to preclude mediation, to preclude it specifically, because that's the only way the court cannot order mediation. And it was done by a lawyer. See, the lawyers are all in on it together. Lawyers become judges, and there's tons of proof on that, and you can figure that out. And that's what we're having is an issue right now where the lawyers are getting together to get money from domestic violence. They get money from the state. The lady who testified earlier gets money from the state.
Okay, if you could suspend for a minute, got to ask one of
Ms.
my
Kulagi?
clerks.
Thank you, Mr. Chairman, and thank you, Mr. Tangway. I just wanted to clarify. So when was, I know you stated that in September of 2022, a parenting plan was filed. When was your case first filed, and when was the domestic violence petition filed?
So they actually filed ex parte on September 19th, 2022. Roughly, we'll give that roughly. If it was at the beginning or mid of September. I did not hear about it until I filed with the mother a demand letter because I had grievances. That's the court, in good faith, you're supposed to do that. November 30th, a domestic violence petition was filed after my November 28th motion with the court to have them order mediation as they're supposed to do. So they did that in direct response. Does that answer your question?
Yes, thank you.
Thank you, Ms. Cattell. So that's just one example. I guess what the main point of my time that I want to make is the best course of action to resolve, because obviously family, at one time children were considered property, and so were women. And that's obviously an important thing to understand. They're not property, but where are they? 173B is unconstitutional. It needs to be repealed. It needs to be taken out of the family courts. The proper procedure is to, if you're a victim, you're scared, you call the police need to do their job. The police are funded by local municipalities. What is happening with 173B is we're actually forcing the state to take on this liability because every single judge is a state employee and every person in the court is a state employee. So my only restitution is not to go and mess around with judicial review committee and file complaints. If you read the Constitution, it is to sue the state of New Hampshire. Another thing I wrote on every one of those papers. So what you're seeing is a complaint with the Manchester Police Department. And they've hired a lawyer and they're not doing it. They're still just refusing to provide service. I have no place to go. On top of that is Miller v. Todd. Miller v. Todd is a very famous case. It's about parental alienation. Do you know how I remembered it? I typed in Miller v. Finger's daughter, NH. I'm sorry, that's disgusting, but that's what I had to type in to remember. And in it, 8 years, a father was falsely accused of molesting his children. The children were alienated. They believed that they were molested. And there's a whole bunch of case law about it. But what we've found is that the mother and their parents basically manipulated the children for 8 years and abused the children to take the custody back and forth. And it involves the Manchester Police. For the last
30 seconds.
Thank you, sir. And I do appreciate it. The last thing I want to do is I want to read the orders, which are false and this should be criminal penalty. This is what I was accused of. This is what the mathematically and physically impossible statements. Initiated 1,100 texts to plaintiff in September 2022. Same again in November, in addition to 52 phone calls computed. Does include numbers she refused to answer. He believes he has a constitutional right to see his children morning and night, and this has hereby been found in her home. He refuses to exit the car after being asked to, and was found kneeling and praying, looking into a slider. The slider doesn't exist. I
Okay,
brought that to the court's attention. May I?
15 seconds and then the mic goes away.
Yes,
Okay.
sir. I brought to the court's attention with 3 pleadings. They denied it. That is with the police. Right now, the Manchester Police, as orders, I can't see my children. I can see my children, and so on. So
Okay,
thank you.
Now it's on my dime. Could you give a fuller reference for Miller v. Todd?
Miller v. Todd, I think it's 2011. I don't have that. I could send it to you, but you can just type in Miller v. Todd.
It's that famous.
It's that famous. It's on the court library website. And the end result was that alienation is just as detrimental to the child's welfare as the actual abuse itself. And this is the New Hampshire Supreme Court. And this
Okay,
is what
so
I'm
this
using.
is a New Hampshire case. We're circling around it, and it looks like 2011. I bet that will be good. Any questions for Mr. Tanguay? The chair recognizes Representative Smith.
Thank you. Just a quick question. Several times you said that mediation is required. Can you give me the citation for that?
Yeah, it's in the family court rules that you can order it. I don't know if it's in 461A, so that's very important. But the only thing that precludes that, and I can provide that to the committee, is a finding of domestic violence. So 173B is unconstitutional because what happens is the process is someone writes a complaint.
I just
you're-
needed the answer to that question. My
Thank you.
understanding is different, but thank you very much.
Okay, we'll check that out. Any further questions of Mr. Tanguay? Seeing none, thank you so much for your testimony. And I am going to, because I know the one pink Carter, it will be here next week. I'm going to now call Joseph Nugent. No more. No more. This is the last person who will be called today. We've already gone well over 12 because I'm a softie. So go ahead, Mr. Nugent. And you're going to...
Thank you, Chairman and
Got it.
committee, for staying late to hear more testimony today. I've been precluded from testifying before because there were too many people and the time had been filled up, so I appreciate what you're doing. The outcome that we're I'm really hoping for is that someone will investigate my case and other cases going on in Carroll County over the last number of years from the Judiciary Committee specifically that may take a closer look at some of the things that are going on in our county. I think that you'll find so many irregularities that will justify your time in looking at some of our cases. Specifically on my case, irregularities happened right at the beginning of the case, which was filed in August of 2016. I was the petitioner on that case. Later, I was accused of domestic violence, and that case was started by my son's mother in March of 2017. I requested expedited hearings, and if the committee would get the transcripts from April 6th of 2017, and then again from April 10th of 2017, I think you'll see that what you're hearing from the interested parties that have presented at the beginning of these meetings is that we're not seeing a rubber meets the road action and what you're being told is happening in the courts. I think if you read those two transcripts, you'll be very surprised at what you read. Specifically, you'll see that I was held to a very specific standard of questioning that only a lawyer would be able to know. So we often hear that the rules of evidence aren't applying, but I was not informed of direct questioning, indirect questioning, cross-examination, but you'll see that I was held to a very, very specific standard in that case. And that began just a long laundry list of abuses, irregularities, due process violations. Please put me in all of those files that you have. But those
Well,
are specific
I'm not
dates.
sure unless somebody is going to volunteer that we will be getting those transcripts. We might suggest rather that you do, because if every person who testifies says, you guys got to go get the transcripts,
I'm
we
sorry, I
won't have time to.
I thought that's what you had said at the organizational meetings that you would be looking at over the summer. I'm happy to provide those for you.
Thank you very much. And if I was confusing, I apologize for that. That'll be very helpful because it will be giving us specific
Yes, I'm
details
happy
from
to
the
do that.
transcript. So thank you so
I
much,
will
sir.
take that on, no problem. I had previously mentioned in the organizational meeting that what happened in the hearing that day was related to RSA 106 H14 as it relates to 911 calls.
Right.
So in that hearing, specifically the DV hearing, which was held on April 10th, I was not allowed to use evidence to refute the allegations made against me. Now, that was allowed in a later, 20 months later, Superior Court case where I was charged criminally, and without the protection of the trial by jury, one of the few rights that still stands in the state of New Hampshire, the government would have put me in prison for 3 to 7 years on completely false allegations.
Did you see a difference between civil court and criminal court in the way that they handled that?
Absolutely, and that's why I'm here to testify today in confirming with Mr. Tangway that I have felt that the domestic violence RSA, I believe it's 173B, is unconstitutional. I believe that it's designed to take away all of my constitutional rights aside from quartering soldiers in my home. It's really designed to make it civil law where someone can make accusations against me. But my understanding is that civil law was meant to be a money problem. If you owe me $500, we go to civil court, not take my child away from having a meaningful relationship with my family, his cousins, my 84-year-old father, my nieces. It wasn't meant to be that way, especially for false allegations, which are provable as false because the 911 call in its full completion has still been withheld from me, and the irregularities and due process violations in my case will show you that despite numerous motions for reconsideration and also appeals before the Supreme Court, the 911 call has never been allowed to enter into evidence in the family court or the domestic violence case, ever, with multiple pieces that you will all receive in those motions. It's horrendous. It's affecting a now next week an 11-year-old child. This has been going on for 6 weeks, 6 years.
And it's impressing itself upon the chair, and I would think others as well, that if the penalty, and I think loss of fellowship with one's family members is a heavy penalty, it may not be called a penalty, but you're being penalized, is of such an order that some of the demands and expenses of criminal court may need to kick in. In criminal court, you've got people doing all the investigating on the state's dime. In civil court, you don't. And if you're going to have such an outcome of this level, then I could see a case being made for this being treated in some ways as if it was a criminal issue, with jury, with investigators paid for, and so on. I think I'm reflecting you back. Am I?
I think that there definitely needs to be change because the bench is for sale in New Hampshire, and this has reached a level of public corruption. This isn't just rule problems. This 911 call being altered is really a criminal matter.
Well, we're not going to be able to go into that as a committee. However, certainly we will look at whether there seems to be some serious need for rule revision. Is there anyone who has a question of our testifier? Seeing none, I want to thank you for coming back and giving us some more, and we'll look for specific details. And with that, I adjourn half an hour late. Thank you for people staying. I've already got some pink cards who will testify next week. If there's any more, I'll take them until I leave in about 5 minutes.